Yeah, please. Let's start.
Good morning to the Honorable Bench, learned councils, and everyone gathered here. If it pleases to your Honorable Bench, I would like to address the bench as your Lordship. Much obliged. Before starting with the competition, we'll have a roll call of all the participants present in the courtroom. HR 12, Speaker 1, Speaker 2, Researcher. HR 16, Speaker 1, Speaker 2, Researcher. Greetings to the Honorable Bench and the participants. We welcome you all to the Surana and Surana Judex 3.0 National Human Rights Law Moot Court Competition 2025. It's a matter of both honor and privilege to have you all in here in this courtroom. With due permission of your Lordship, I would like to enlighten the members of the team with the rules and regulations of the competition. Much obliged. The language for the competition shall be English. Each team will get 45 minutes to present their case. That will include the rebuttal time. The division of time is at the discretion of the team with a minimum of 20 minutes per speaker. The oral arguments need not be confined to the issues presented in the memorials. The researcher shall sit with the speakers while during the oral pleadings. Any identification of the college name during arguments will lead to immediate disqualification. You are expected to adhere to courtroom protocols and maintain decorum while court is in session. Any contempt will lead to disqualification. Now, if the participants are ready and your Lordship permits, the court shall start with the proceedings. Much obliged, your Lordship. The court is in session.
Greetings to the bench. The council seeks permission of the Honorable Court to address the bench collectively as your lordships. Much obliged. May it please the court, I am Speaker 1 of HR 12, counsel for the petitioner in the case of Ankshita Rathi versus the state of Uttar Kosh and another. Your lordships, I will be dealing specifically with issues 1 and 4. Taking up 20 minutes of the court's time, and my co-counsel will deal with issues 2 and 3, taking up 20 minutes of the court's time, and we reserve 5 minutes for the rebuttals. If your lordships are well versed with the facts of the case, may the counsel proceed with the jurisdiction? Indeed, your lordship. Your lordship, on 11th March 2024, the state of Uttar Kosh enacted its own UCC, wherein Ankshita Rathi was a resident of Uttar Kosh and Zishan Khan, who is a Muslim but non-resident of Uttar Kosh, entered into a live-in relationship in Bomba, but due to some differences, they broke apart, and later on, Zishan married another Muslim woman named Nusrat, and at the same time, Ankshita realized that she is pregnant and went to reconcile with Zishan. Both of them decided to register a live-in relationship or a marriage under the UCC of Uttar Kosh, which was denied on the grounds that Zishan's existing marriage renders the relationship void and that Ankshita is less than 21 years of age and needs parental consent for the same. Ankshita has filed a writ petition in this Honorable Supreme Court under Article 32, challenging the validity of the UCC and the actions of the Registrar General. If your lordships permit, may the council proceed with this jurisdiction. Much obliged. Your lordships, the petitioners has approached this Honorable Court under Article 32 of the Constitution of Aryan, invoking its jurisdiction for the violation of the fundamental rights. With your lordships' permission, may the council proceed with the issues? Much obliged, your lordship. Your lordship, the first issue concerns with whether the Uttar Kosh UCC's bar on polygamy and live-in relationship registration violates Article 21 and disregards the principles of secularism, federalism and public consultation. It is most humbly submitted before this Honorable Court that indeed the implementation and the enactment of UCC is violative of the fundamental rights and the constitutional principles. Your lordship, the petitioner structures its argument in two folds primarily. The first one, that the impugned provisions violate the fundamental rights of Article 14 and 21 of the petitioners, and secondly, that the court directly conflicts with the foundational constitutional principles of secularism, federalism and participatory constitutionalism. Your Lordship, moving to the first part of my first submission, Article 14 is one of the most cherished rights, and it enshrines two essential guarantees. One is equality before law, and second is equal protection of law. If any law seeks to curtail such rights, it has to pass the twin test which was laid down in the case of West Bengal, State of West Bengal versus Anwar Ali Sarkar. Your Lordship may refer to flag 2 of the given compendiums for the requisite highlighted parts of the judgment. Your Lordship, in the present instance, there exists a glaring inconsistency within the provisions of UCC itself. Specifically, on the grounds of marriages, firstly, Section 4, subsection 1, which is enumerated in flag 18, and proviso B to Section 7, subsection 2, flag number 20. Your Lordship, while Section 4.1 mandates monogamy for all marriages post-enactment, Section 7, subsection 2's proviso creates an exceptions for the same. Any marriage which was solemnized before 2010 or outside Uttar Kosh before the implementation of UCC, wherein at least one party was a resident of Uttar Kosh, even if it is a polygamous marriages which is allowed by customs and usages, are to be registered under the UCC itself. Which means, Your Lordship, the UCC in itself is creating a non-intelligible classification between the people of the same community who follow the same customs and usages. It is giving the the recognition of those customs to people who have married before and earlier. But in the same case, when of the people of the same community, of the same customs and usages, when they are marrying post-enactment, they are denying their customs and usages. The state has unreasonably classified between the people of the same community. Your Lordship, based solely on the...
But are they of the... Are they belonging to the same community? Both Anshita and Zishan? But they are not from the same community, right? But you just said that they are from the same community. Use your mic.
Hello. Your Lordships, they are not of the same community. The classification is being created for the people who follow one community, which is the Islam religion. They are allowed to marry 4 times. It is quite specified in centuries. So, Your Lordships, my contention here is that Zishan, being a Muslim person, is being denied the right to exercise his own customs, to follow his own customs. If he wants to marry Anshita as his second wife, it is being denied, and it's based on a completely arbitrary ground. Your Lordship, our contention is against the selective recognition which the UCC has done. It should have either been uniform exclusion or uniform inclusion, Your Lordship. They have done nothing. They have stayed in the grey area, and they have tried to have a target interference within the communities which are specifically being violated. Your Lordship, moving ahead in the matters of live-in relationship. Your Lordship, the provisions related to the live-in relationships are provided under flag 24 and in the subsequent pages of flag 24. Your Lordship, the provisions related to live-in relationship again fail to pass the twin test under Article 14. Your Lordship, Section 378, subsection 2 provides that even if one of the partners is of the resident of Uttar Kosh and a live-in couple is living outside the state of Uttar Kosh, they may submit a statement of live-in relationship, and thereby it becomes a discretion. The enumeration of the word may, Your Lordship, it clearly shows that the couple has an option of whether they want or whether they do not want to register their live-in relationships. Your Lordship, however, under Section 381, subsection 1, read with Section 387, subsection 1, they mandate the submission of such statement for the registration purposes and add penal consequences for those couples which do not register, Your Lordship. Your Lordship, the ambiguity of this law is at question here, because, Your Lordship, if the law itself providing for the option to a couple that they may or may not want register a live-in relationship, which is a great deal of privacy for if a couple wants to register or if a couple does not want to register. It is at their discretion. They have given that in one section, but your lordship, we move ahead in the same part, in the same chapter, they have added penal consequences to the same. Your lordship, if it is supposed to be compulsion, then why not enumerate it directly? Why make a may provision, then again make a shall provision? This distinction is nowhere intelligibly differentiated. Also, your lordship, in both the matters which I stated about the marriage as well as the live-in relationships, the object of this code has been highlighted as uniformity. If the object is uniformity, then creating this arbitrary distinction with no intelligible differentia has no rational nexus with such objective, your lordship. And it was clearly stated in the state of West Bengal versus Anwar Ali Sarkar that if any of the twin tests is failed, then the law is considered arbitrary and amounts to a violation of Article 14, your lordship. Your lordship, moving ahead to my second contention of the first submission. For Article 21, which is the violation of Article 21 for the petitioners. Your lordship, Article 21 gives a plethora of rights on individuals. One of such rights is right to privacy. Your lordship, I would like to take to your attention flag 3 of the given compendium, in which Justice K.S. Puttaswamy versus Union of India has been highlighted. Your lordship, it was held that privacy at its core includes the preservation of personal intimacies, the sanctity of family life, marriage, procreation, the home and the sexual orientation, your lordship. Your lordship, in this light, I would like to enumerate my contentions. In the matters of marriage, firstly. Your lordship, section 6, which is enumerated in flag 19 of the compendium, makes registration of a marriage as mandatory, which means the details of the couples, whether it is name, age, their address, each of those intimate details are to be maintained in the marriage and divorce related registers. Your lordship, when we read into section 15 of the UCC, flag 22, it allows unrestricted public access to marriage and divorce related registers of the public. Your lordship, giving certified copies of these intimate details to any person, whomsoever, is completely violating and holds a serious threat to their right to control sensitive and intimate personal information, your lordship. Information that by its nature should not be exposed to the public scrutiny. Your lordship, when people with good intention may come, it's undisputed that people with good intentions will also try to access the register. But your lordship, what about the safeguards needed when there is a person with ill intention approaching the registrar to give them the certified extracts? How is the registrar supposed to know that whether the person in front of him has a good intention or a bad intention? There is no safeguard whatsoever provided, your lordships. It's just a procedure and a payment of a requisite fee, your lordship. And this in itself holds a serious threat to the right to privacy. Indeed, your lordship. Indeed, your lordship. Your lordship, the issue that has been framed, it questions about the provisions which specifically deal with the restriction of polygamy and the restrictions of live-in relationship registration. Your lordship, these are the provisions that deal greatly with those. Your lordship, as I... Yes, your lordship. Yes, your lordship.
How is it supporting your case? How is it supporting the argument in hand? You're saying that Article 21 is
Indeed, your lordship. Your lordship, the personal the provisions which have violated our rights are dealt in issues 2 and 3. Are the provisions that are violative of the fundamental rights of the UCC as a whole. Your Lordship, it has been held in numerous cases that the statute must be read as a whole. And Your Lordship, when we are contending that these are the provisions that personally violate our fundamental rights, we surely will provide the court with more provisions which are violative of fundamental rights. Your Lordship, it was held in the case of Navtej Singh Johar versus Union of India that the courts have to interfere at a very early stage.
You have not upon the polygamy. That was one of the strongest reasons for the denial by the registrar. It has not yet come up neither in the facts nor in the grounds or the arguments which you are taking. What about that? Because that as per the facts of the case, that was one of the major reasons for the denial.
The marriages which have been taken place pre-enactment has been allowed and being registered under the UCC itself. But Your Lordships, post-enactment phase, which is the phase we are currently in, the petitioner is currently in the phase of post-enactment, they have been denied. Your Lordship, this is the first contention I made, that the proviso B to section 7(2) carves out an exception to the rule that monogamy is compulsory. Your Lordship, that was my very first contention, that Article 14 gives the equal treatment to all. But Your Lordship, in the present instance, the polygamy was denied to our petitioner, and thereby my contention was at its core dealing with polygamy, Your Lordship. Your Lordships, may I move forward? Much obliged. Your Lordships, continuing where I was, Your Lordship, under Article 21, right to privacy, Section 381, subsection 3, again enumerated in Flag 24, the Uttar Kosh UCC has granted unchecked powers to the registrar to conduct summary inquiries during the registration of live-in relationships. It authorizes the registrar to summon not only the partners, but any other person which he thinks is fit for verification and demand further information or evidence of the same. Your Lordship, if it would have been compulsion that in front of the parties, the other parties will come, or any other person, which has nowhere been defined in the definitional framework of the UCC. The any other person terminology has not been defined. So, Your Lordship, it can be anyone in the territory of India. So, in the present instance, if the partners are not present, the registrar has the power to call upon anyone, which can either give a beneficial verification or which can go against them, Your Lordship. Your Lordship, the enumeration of may, again, he may or may not call the parties or the couple. So, Your Lordship, it again, without any procedural safeguards, it opens the door for arbitrary interference, Your Lordship. On the same note, these unchecked intrusions into the life of couples, regardless of the fact whether they are opting for marriage or live-in relationship, is grave violation of Article 21's rights, Your Lordship. Your Lordship, moving to my next contention, the second submission about the constitutional principles. Your Lordship, firstly, I would like to take to your attention, Your Lordship, the Rajiv Suri case, the Rajiv Suri versus Delhi Development Authority case, which is in flag number 4. Your Lordship, it was held that if a public consultation is denied before the enactment of a legislation, it is clearly a violation of the freedom of speech and expression, which is one of the rights under Article 19, Your Lordship. And Your Lordship, this is a catastrophic situation, as because even the Honorable Court will not have the option to provide remedy once this has been denied, because the state cannot go back again to the pre-enactment phase. It will have to stay in the post-enactment, and once it has been violated, there is no coming back to where it was. Your Lordship, on this note, public consultation is not merely aspirational. It is firmly embedded in the democratic framework. Your Lordship may refer to flag 16 to refer to the pre-legislative consultation policy of 2014. This policy was introduced with the express purpose of enhancing participatory democracy, Your Lordship. It requires and makes it obligatory for every department or ministry to actively seek comments, suggestions and opinions from the public, especially from those minority communities who are more likely to be affected, before a bill is drafted and enacted, Your Lordship. Since its inception, Your Lordship, it's not just means perfectly done or anything. It has not been done. It has been completely ignored. There was no public consultation done whatsoever. Indeed, Your Lordship. Your Lordship, it can be inferred from the fact number 3, where it was stated that the law has been hastily passed. Your Lordship may refer to page 2 of the proposition, wherein the first line says that furthermore, the lawmakers hastily passed the law to suppress the rights and religious freedoms of certain religious groups, premising upon their minority status, Your Lordship. Your Lordship, the public consultation concept is usually where the government or ministry or the department has to consult with the publics, the scholars or the general people as a whole. But Your Lordship, that is something that takes time. Yes, Your Lordship. Your Lordship, a bill is introduced in the Legislative Assembly, and if a majority of the people agree to it, and then it is passed. And in this, yes, Your Lordship. No, Your Lordship. Your Lordship, because there is no such confirmation as to all the people who are in the Legislative Assembly of the state are actually aware of the minority people. Your Lordship, let me complete. Your Lordship, the point as of there is no ratio as to the minority community specifically being represented there. Your Lordship, the public consultation is to be done if there are adequacy in the representation. It's not exactly, it cannot be contended that the representation was adequate. Maybe if the majority of the representatives were of the majority community, they would have supported this law, Your Lordship. Your Lordship, it is not the entire reason on this, it cannot be declared as ultra virus, but Your Lordship, they have completely violated the fundamental rights. Your Lordship, also as for the representation purposes, it is the majority party which is at the rule, and we have some anti-defection laws, Your Lordship. If they are not to follow the party's whip, which has given the bill, obviously the majority party, the party at rule does it. If they go against, the representatives go against the bill, they will have to face complete discard from the party itself, Your Lordship. So the defection will lead to direct submission, Your Lordship. Your Lordship, yes, Your Lordship. Yes, Your Lordship.
No adequate representation had not been provided. It doesn't say no consultation, it's adequate representation had not been provided. So there
Yes,
is
sir.
representation was provided. So when you make a statement to the court that no public consultation was done, it's a very strong statement.
Indeed, Your Lordship.
You have to support it with some
Yes, Your Lordship.
facts as well. So move on.
Indeed, Your Lordship. Indeed, Your Lordship. Your Lordship, it was the silence of the facts which I think both the sides will try to interpret in their own way. So we try to interpret that. Yes, Your Lordship. Yes, Your Lordship. Indeed, Your Lordship. Your Lordship, moving to the statement of Dr. B.R. Ambedkar in the Constitutional Assembly debate, it was clearly said that the Uniform Civil Code, although it was aspirational, if it comes into force someday in this country, should be made as an option at the very beginning. Your Lordships, if it was supposed to be optional at the very beginning, we compare the Goa UCC there are 2 states in this country as of now which have UCC as their law. Your Lordship, the Goa UCC has ensured that there is an option of the people to whether they want to be governed under the UCC or whether they want to be governed under their personal laws. Your Lordship, this has been again debarred from. There has been no option given to the people or the residents of Uttar Kosh. It is directly debarring them from following their personal laws, Your Lordship. Yes, Your Lordship. If Your Lordships are with me, can I continue? Yes, Your Lordship. Thank you. Your Lordship, these provisions or these enactment which was failing the public consultation or adequate public consultation as my Lordship provided, is in complete violation of the rights. Your Lordship, moving to the part of federalism, if Your Lordships are with me, please may I continue? Yes, Your Lordship. Your Lordship, under Article 254, Clause 2, they have enacted this law by the presidential assent, but it nowhere safeguards this law from the judicial scrutiny, Your Lordship. Your Lordships, the point of federalism, I would like to grab to your attention the extra Constitutional Assembly debate that we provided. Your Lordship, it was said again by Dr. B.R. Ambedkar that it is the Parliament which will enact such law. Because the aim of Article 44 is to have a uniform civil code across the territory of India, Your Lordship. Your Lordship, if each state moves ahead and makes a uniform civil code, then again, the aim of Article 44 is denied. Because again, all the states will have different laws. There will be no uniformity which will be achieved, which is the original aim of Article 44. But Your Lordship, here the Parliament is Parliament supposed to, the UCC is supposed to be enacted by the Parliament as a whole for the entire country, Your Lordships. But here the state has enacted it. They have cleverly taken the presidential assent, and that makes them safe from doctrine of repugnancy. Surely. But Your Lordship, the judicial scrutiny, the violation of fundamental rights cannot save this law. Your Lordship, this statement will be further enumerated in detail by my co-counsel as to why this law cannot be saved. Your Lordship, moving to my last submission of this issue, it is that the petitioner submit that this is a targeted interference into the lives of minority communities. It is clearly stated in the numerous cases that Article 25 ensures that all the people have the right to practice, propagate and have the religion freely. Your Lordship, in this case, the rights, the customs, which are supposed to be their own and are to be practiced unrestrictedly, they are being denied. Your Lordship, the definition of secularism in the Indian context as defined in S.R. Bommai versus Union of India, it was that the state has to maintain an equal distance from all the religion. It is not the layman definition that the state has no religion or other definitions. It is that the state has to ensure that the state is equally distant from all the religions. But Your Lordship, in this case, they have targetedly supported the majority community and defied the rights of the minority communities, Your Lordship. Your Lordship, in the lights of above submission, it is contended that UCC violates the fundamental rights as well as it violates the constitutional principles of federalism, secularism and public consultation, Your Lordship. On this note, I want to continue with my fourth issue, Your Lordship, which is whether the rights enshrined under Article 25 and 21 of right to cohabitation is being violated by the Uttar Pradesh. Your Lordship, as I was previously contending, definitely the state has interfered with the right of the practicing religion, Your Lordship. Your Lordship, as it was stated in the case of Tilkayat Shri Govindlalji Maharaj versus State of Rajasthan, which is enumerated in flag 14 of
Sorry. Where is your fourth issue? Does this have all those four issues? No, this is on behalf of the petitioner, counsels for the petitioner. They're the petitioners. Because it's not the fourth issue which is same as what is here. It's not the issue which is same as what is here. Because that's what I'm unable to refer to, that where are the issues which you are arguing? I mean, they are not matching.
Yours is the right one?
May I continue, Your Lordships? Your Lordship, as I was stating, in the case of Tilkayat Shri Govindlalji Maharaj versus State of Rajasthan, this particular part was also reiterated in the Sabrimala case, which is the Indian Young Lawyers Association case, enumerated in Act 14 of the compendium, that whether a practice is integral to a religion must be determined by the belief of the community itself. Your Lordship, polygamous marriages in Islam have been long recognized within certain religious customs. It has been enumerated in verses of Quran itself, which means that everyone in the entire community believes that it is a integral belief of the religion, Your Lordship. Although not everyone follow it, but people who want to follow it, they do. And it cannot be restricted on the grounds of uniformity, under the guise of uniformity, Your Lordship. Under the guise of uniformity, each one should have been treated equally. No, if the rights are being curtailed, then curtail it as a whole, on the legitimate grounds which have been enumerated by this honorable court. But Your Lordships, they have curtailed on arbitrary grounds, which is unacceptable. Your Lordship, also coming to the case of Ratilal Panachand Gandhi versus State of Bombay, the honorable court cautioned that no secular authority can determine what is essential to a religion or interfere arbitrarily in religious affairs, Your Lordship. This has been enumerated in flag 15. Your Lordship, flag 15, the citation is AIR 1954, Supreme Court 388. May I continue, Your Lordship? Much obliged. Your Lordship, this is precisely what the UCC of Uttar Pradesh has done. They have interfered into the customs of people who have followed it for centuries with no probable cause. Your Lordship, if they are contending that it is on grounds of social order or public morality, this was not hampering anyone's morality, Your Lordship. It is their own belief which they were following. If Your Lordship may grant me just a couple of minutes so that I can conclude with this argument. Yes, Your Lordship, more than enough. Your Lordship, turning to Article 21's right to cohabitation, it was enumerated in the case of Safin Jahan versus Ashokan and Afghan Singh Johar versus Union of India that the right to choose one's partner and the right to live with dignity are intrinsic to Article 21. Any attempt by the state, Your Lordships, to regulate such choices are to withstand the strictest constitutional scrutiny. Your Lordship, the UCC of Uttar Pradesh is trying to interfere into the personal choices of the people to choose a spouse. Your Lordship, it is intrinsic, it is almost absolute. If a person wants to live with another person, why is the state interfering as such? Your Lordship, in turn, as my concluding point, this Uttar Pradesh UCC is, while claiming uniformity, has been violating Article 14, 19, 21, 25 and all the constitutional principles such as the secularism, federalism, and public consultation, Your Lordship. Your Lordship, when we speak about the Article 14, 19, and 21, it is one of the most strictest forms of test that a law needs to pass, which is known as the Golden Triangle Principle, enumerated in the Menaka Gandhi case, Your Lordship. And Your Lordship, this law fails all of them. If Your Lordships have no further questions for me, I'd like to call upon my co-counsel who will deal with the further issues. Much obliged, Your Lordship.
The council seeks permission to proceed. Much obliged, Your Lordship. Yes, Your Lordship. Your Lordship, I will be dealing with issue 2 and 3. Issue 2. Yes, proposition, Your Lordship, the memorial. Yes, sir. We are dealing with the same issue, Your Lordship. Yes, sir. B and C, Your Lordship. Yes, Your Lordship. In the memorial, Your Lordship, 2 and 3. 1 and 4. A and D. Yes, Your Lordship.
And in your memo, you are
Issue 2 and issue 3. Begin, Your Lordship. Yes. Your Lordship, issue 2 states that whether the requirement of parental consent for the live-in relationship registration in case of individuals under 21 years is constitutionally valid under Article 14 and 21 or not. Your Lordship, I will be submitting my contention under two folds. Your Lordship, first being the violation of Article 14 and second being the violation of right to privacy under Article 21. Your Lordship, I am first dealing with the violation of Article 14. That is, Your Lordship, the unjust classification has been done by this UCC between the age group of 18 to 21 years of people and the people above 21 years, Your Lordship. And this classification has not been done intelligibly and has no rational nexus, Your Lordship. Your Lordship, I will be proving this with the help of the sections of UCC, Your Lordship. Your Lordship, may please refer to fact number 24, Your Lordship, of the compendium, section 380, clause 3 of UCC, Your Lordship. Your Lordship, it clearly states, one who is above 18 years of age, that means one who is not a minor, he is allowed to register under UCC, Your Lordship. But the same act under section 385, under the marginal note of duties of the registrar, again specifies, one who is below 21 requires parental consent, Your Lordship. Your Lordship, our contention is, if the procedural mandate of the act is stating one who is above 18 can register himself or herself for the live-in, then why the parental consent is given as a way under the duties of the registrar and giving an arbitrary power to that person upon whom our right is depending, Your Lordship. If the welfare intention of the state was there to register above 21 years of age, then why the procedural part of the act mentions above 18, Your Lordship? It should have mentioned above 21 years, but it is not mentioned. It has mentioned one who is above 18, he or she can register. But again, in the duties part, it is giving another way. If someone wants to register below 21, parental consent is required. So it's two-way out, your lordship. So that classification doesn't anyway has rational nexus with the objective of the UCC source to achieve, your lordship. It is our contention under Article 14, your lordship. Yes, your lordship. Parental consent. Yes, your lordship. By 385, yes, your lordship. It states that it will identify the information will be given to the parents, your lordship. Yes, your lordship. But if the parents deny, your lordship, it doesn't anywhere also mentions the registrar will register or deny that. That remains a question mark, your lordship. So that's why we are contending, your lordship. Much obliged, your lordship. Yes, sir. Yes, your lordship. As it states that only to notify the parents. But as your lordship asked, if the parents deny in some cases, will it be able to register or not? That is also not mentioned in the act, your lordship. So that is not mentioned. It will allowed or denied, that is not mentioned. Yes, your lordship. Yes, your lordship. Parental consent, your lordship. Yes, your lordship. Also the rules, if your lordship may go to the 15th clause for the annexer 29 of the UCC rules, then it also states that the intimation will be given by email or by the hard copy also, your lordship. So our contention, lordship, is if the UCC wants to register below 21 or above 21, it should have been mentioned under 380 clause 3. So why 380 clause 3 mentions above 18 years of age is allowed to register? If above 18 years of age is allowed to register, then why below 21 parental consent is mentioned in 385? That is the classification that has been done, which we challenge, your lordship. Yes, your lordship. Your lordship, under the duties of registrar, it's mentioned without completion of duties, will the registrar allowed to register? No, your lordship. Obviously, when someone comes to register, your lordship, it is first refer to the duties of the registrar, then it has to comply with all the procedures, then only register. If the procedure is binding on the registrar to intimate the parents of the couple, then the parents deny, no, we don't our child to register. Then in that case, will the registrar go with the parents' permission or go with the consent of the parties? The act is silent about that part, your lordship. No, your lordship, the permission is not expressly mentioned. Your lordship, I am just contending that if in some case, when the intimation is given to parents and parents deny that, then in that case, will the couples will allowed to register or not? Because without complying the duties, will the registrar be allowed to register the couples, or it will wait for the intimation confirmation? As mentioned in the rules, we have just referred the rules, your lordship, Annexure 29, which clearly says a written information will be given to parents, your lordship. The UCC rules, your lordship, we just forwarded, your lordship. Yes, your lordship. If the parents deny, then the registrar will listen to the parents or will go with the couples to register, your lordship. That is our contention, your lordship. Your lordship, also in the facts, if we refer, your lordship, if we refer to fact number 8, your lordship. Your lordship, it clearly states, however, the Registrar General refused to register the marriage because Ankshita's age was below 21 years and the consent of their parents needed to be present, your lordship. Yes, your lordship. I am challenging why the classification has been made between the age group of 18 to 21 and above 21, your lordship. Yes, Your Lordship. I am contending that, Your Lordship, it's treating the age group of 18 to 21 in one way and treating the age group above 21 in other way, Lordship. And the way of treating both has no rational nexus, Your Lordship. If a person is above 21, no parental consent is required, he is or she is allowed to freely register, then why a person below 21 or the age group between 18 to 21 require a parental consent? Whereas the Act itself mentions who is above 18, he or she can register. Then we will go by the procedural words of the UCC of the Your Lordship. Yes, Your Lordship. Twin test is failing, Your Lordship. The intelligible difference as well as the rational nexus, because this sort of classification has no rational nexus, the objective of UCC, which is sought to achieve, Your Lordship. And if the Act sought to do that, it would have mentioned in the procedural part, but it has mentioned one who is above 18, he or she can register. Then by the words of that, we could have registered, Your Lordship. Yes, Your Lordship. His Lordship, the procedural part has to be dealt with line with the substantive part, Your Lordship, but has to be dealt in line with procedural part, always has to be dealt in line to substantive part, Your Lordship. Your Lordship, the ambiguity of the law we are challenging, Your Lordship. The ambiguous part of Your Lordship. The procedural part states above 18 who is not a minor, and the Act also defines minor, one who is above 18. He is not defining anywhere 21 years of age. But the duties part of register is focusing above 21 years of age. The procedural part doesn't say anything above 21. It only states about 18 years. So if we are above 18, we should have allowed. But we are not allowed in this case. And the parental consent is being forced upon us. That is the challenge, Your Lordship. Much obliged. Your Lordship, with this I have completed the issue 2, that is the parental consent part. I will dealing with issue 3 further, Your Lordship. Your Lordship, issue 3, does the denial of registration of the marriage or live-in relationship of Ankshita and Zishan impact the right to paternity, legitimacy and welfare of the unborn child? And can such rights be read within Article 21 or not, Your Lordship? Your Lordship, I will be submitting my contention again under two folds. That is, the arbitrary power vested on Registrar General is violative of fundamental rights, and these rights can be very well read under Article 21, Your Lordship. Your Lordship, if Your Lordship may refer to flag number 21 of the given compendium, the section 14 of the UCC has been highlighted, which clearly mention the words final and binding decision of Registrar General, Your Lordship. It clearly states, Your Lordship, if someone is denied the registration, the words of the Registrar General is final and binding, and it is restricting the judicial scrutiny, Your Lordship, again. Yes, Your Lordship. Yes, Your Lordship. Yes, Your Lordship, unborn child has to, if the child has not, unborn child means the child has not yet been born, Your Lordship. And for being future it will be born, Your Lordship, the legitimacy, the welfare, the paternity, all has to be secured, Your Lordship. If this all has been denied by the law, yes, Your Lordship. Yes, Your Lordship. Yes, Your Lordship. Yes, Your Lordship, because abortion has been, abortion cannot be done on the basis that you don't want a child, so abort, because that child also has a right to life under Article 21. So abortion is done only in specific cases, Your Lordship. From that we can construe. Yes, Your Lordship. Your Lordship, as the issue states, does the denial of registration impact the relationship of Ankshita and Zishan? First part is that, Your Lordship. And again, impact the right to paternity and welfare of the unborn child, Your Lordship. And the right to livelihood, right to dignity of that unborn child also. That comes under Article 21, Your Lordship. So from that we say that all this unborn child's paternity, legitimacy, welfare requirement can be said to read under Article 21, Your Lordship. From that part. That is why we are arguing the point that this three things depends upon the Registrar General, who has been given arbitrary power under many sections, and if he denies this relationship registration, indirectly the child is being hampered, Your Lordship. So for the welfare concern of the child, the registration has to be recognized, Your Lordship. For the future concern, for the welfare, which is of paramount importance, Your Lordship. Much obliged. Your Lordship may refer to flag number 21, which was stating that final and binding decision of Registrar General, Your Lordship. If the decision of the Registrar General will be final and binding upon the parties, it clearly prohibits the judicial scrutiny, Your Lordship. First of all, he states if someone goes to sub-registrar, his decision is not applicable, then he may appeal to registrar, then he may appeal to registrar general. But after that, he has no scope has been given for the judicial scrutiny or judicial review. It says the rewards of the registrar general shall be final and binding, which we challenge, your lordship. And again, if my lordship may refer to flag number 24, section 381, clause 4 of UCC, your lordship, which again gives the unchecked power of the Registrar General on live-in relationship registration, your lordship. And simultaneously, as my co-counsel also mentioned, your lordship, the summoning power. It can summon any person for the registration of this couple. It does not mention any family members or close ones, nothing. It can summon any person, your lordship. So, your lordship, the executive body has been given the arbitrary power and violating the judicial review through this act. And the act is giving the unchecked power on the Registrar General, your lordship. No, your lordship, specifically has not been mentioned. Your lordship, why we didn't come under 226 under high? Your lordship, as UCC has been challenged here. If your lordship, this is the Supreme Court, is the apex court, it's the law of the land, your lordship decision. If in future any other state enacts UCC, then it will lead to multiplicity of litigation. But once UCC is denied unconstitutional on these grounds, every state will get a law to know to enact the law on basis of these grounds on which this law has been declared unconstitutional, which will prevent multiplicity of litigation, and also it will binding on all the people and securement the rights of all the people, your lordship. Your lordship, if we wanted to challenge only this part, we may have gone. But if we see the 4 issues, all things are present, your lordship. Federalism is present, your lordship. Secularism has been challenged, and all this cannot be challenged under 226, lordship. To challenge everything under 4 issues, we need to come to the Supreme Court under 32, your lordship. We have just referred a case, your lordship, Kothari versus State of Madras, your lordship. It clearly states the existence of other remedies doesn't bar us to come to the Supreme Court under Article 32. So if it isn't a bar, and Article 32 is itself a fundamental right which we can enforce, your lordship. So by that we have approached the lordship.
But still, you could not convince us as to how they say that it is initially barred by these provisions.
Your lordship, the words final and binding written in the act itself. It's if the words of the Registrar General is final and binding upon the parties, then where the parties will further appeal. It has not mentioned any provision. It has mentioned if the sub-registrar is not, if you are not satisfied with the sub-registrar, you may appeal to registrar. You may appeal to Registrar General. But the next line is not present. You may appeal to judicial also. It's written Registrar General is the final and binding body, which you have to follow. So that is why we are contending that if the words of the Registrar General is final and binding, there is no scope for judicial review also. Much obliged, your lordship. Your lordship, further, as my co-counsel already dealt, the summoning power has been granted to any person. That is also an ambiguous and arbitrary power, your lordship. Your lordship may refer to flag number 22 and 24 for the privacy part, your lordship. Under section 15, section 381 clause 3 and section 385 clause 1, your lordship. It's hampering the privacy of the person's right to privacy under article 21 of the person by the arbitrary power given to Registrar General, your lordship. And also, your lordship, if your lordship may refer to flag number 23. If your lordship are with me, continue, your lordship. Much obliged. If the flag number 23, your lordship states, section 20, which a non-registration of marriage is not invalid. Your lordship, if registration under section 6 is compulsory, and again the same act says, section 20, that non-registration does not render the marriage void, then what is the use of the mandatory clause, the registration is shall word, your lordship. That is the again ambiguity part we challenge, your lordship.
Just continuing with what my learned brother asked, 226 we can understand you and may not be fully ready. But you never thought of filing an appeal against this order because the statute talks about filing an appeal against the denial of registration. You can speak. No, appealing as per the provisions of the Act which you have highlighted. Flag 21, Section 14 talks about appeal against rejection of registration. So you went to Registrar General for
Much obliged, Your Lordship. Your Lordship, again, as I was dealing with section 20 of the UCC, flag number 23, it states, non-registration of marriage is not invalid, Your Lordship. Section 6 of the same act says, registration shall be compulsory post enactment of UCC. But again, the same part, act, section 20 says, if someone is not registering his or her marriage, his marriage is not invalid. If registration is compulsory, and the same act is again saying that marriage registration is, if not done, the marriage is valid and is not invalid, then what is the use of registration, Your Lordship? Again, that is the ambiguity part we challenge. And also, Your Lordship, registration is optional under UCC, Your Lordship. Registration is optional, one may register, one may not register. But for the optional registration, punishment is become mandatory, Your Lordship. If someone is given an option to register or not to register, then why the punishment or penalty part is binding? It again saying that if someone is not registering, he shall be punished. But registration is optional. So if someone chooses not to register, then why shall be penalized, Your Lordship? If registration has to be compulsory, he didn't did, then he should be penalized. But optional option has been given to register or not to register, but option has not been given for the penalize. Penalize has been compulsorily done under section 387 of the UCC, Your Lordship. Your Lordship will refer to flag number 24 for the live-in relationship part, Your Lordship. So that is all the ambiguous power that has been given or vested on the Registrar General, Your Lordship. And also, Your Lordship, if you will see the doctrine of severability also, Your Lordship, that cannot save this Act UCC, Your Lordship, because the so many provisions are so inextricably connected with the Act, Your Lordship. If we sever all these provisions, the Act has itself no core function, Your Lordship. So by this we contend, by Article 13, if so many fundamental rights are being violated by this Act, the law should be declared as void, Your Lordship, before this honorable bench. That much we contend, Your Lordship. Your Lordship, we may refer to the UDHR of the human right part. Article 12, 16 and 18, Your Lordship, of the UDHR. And also we have proved the fundamental rights under Article 14, 21, Your Lordship, already. And also the UDHR Article 12, 16 and 18 have been violated. So the human rights of us are being violated, Your Lordship. Because we are aggrieved by this Act, new Act, for which we are denied registration. Because if this UCC would not have been there, the personal laws would have been there, and the Zishan being an Islam man, he would have married Angshita, and he is capable enough to have two wives, and by Muslim personal law, he has the power, he has the authority to give keep four wives, Your Lordship. But for this UCC, the child, unborn child's interest has been hampered, as well as the Angshita's and Zishan's interest has been hampered, Your Lordship. If this law would not have been there, all would have run smoothly, and because the state has power, which we also agree, to enact UCC, they enacted, but if a thing is running peacefully, and if someone has power, it will enact such a law which will violate fundamental right of other person. That is not accepted, Your Lordship. That much we contend, Your Lordship. Your Lordship, we should allow to preserve our custom, Your Lordship. Yes, Your Lordship, we should allow to preserve our custom, and we should allow to profess our custom under Article 25, Your Lordship, as a religious part. So, because of with UCC, we have been apprised by that. So, we contend to declare this UCC as unconstitutional so that we may enjoy our rights under our personal law, Your Lordship. Your Lordship, Your Lordship, by converting Angshita into, we may do that. Because Lordship, it clearly states that if someone is a resident of Uttar course, then he has to register herself or himself under UCC if one of the parties is also resident of Uttar course. As Angshita being a resident of Uttar course, Your Lordship, optional registration for live-in. Your Lordship, optional registration for live-in, but marriage registration is mandated, Your Lordship. If marriage registration is mandated and we want to marry under a personal law and being a resident of Uttar Coast, how we will convert, Your Lordship? If this law would not have been there, then only we would have that option. So that is where appealing, Your Lordship. Your Lordship, this doesn't deny our conversion, but it mandates every citizen of Uttar Coast has to register if going to any relationship, if it may live in or it may be marriage, Your Lordship. So that is why we are contending. Your Lordship, it's if we follow the Your Lordship, if we go by the UCC's Bare Act, it has regulated many of the Act, Your Lordship, like Hindu Marriage Act, Hindu Succession Act, Special Marriage Act also, Muslim Divorce Act, Muslim Marriage Act. So everything has been regulated and kept, and this Act are not applicable under Uttar Pradesh, Your Lordship, now. But it has not included the Guardianship Act and the Minority Act, Your Lordship. Minorities, the Special SC/ST Tribes Act, that is has been not been hampered. But it has ignored the minorities, that is the Muslim community specifically. So if an act is dealing with the uniformity part, then why it has not included the adoption part, guardianship part, and why it has only focused on the marriage, divorce and succession part, Your Lordship? So that is again also challenging the uniformity of the act, Your Lordship. If the intention of the legislature is uniformity, it should have dealt with all the personal aspects, but it's only dealing with the marriage and divorce. For what about the guardianship and adoption, Your Lordship? So that again comes into question. So that is why we challenge this law to be declared as unconstitutional, Your Lordship. Yes, Your Lordship. Before the enactment of UCC. Yes, Your Lordship. Your Lordship, as Your Lordship, if yes, Your Lordship. Yes, Your Lordship. Yes, Your Lordship. Yes, Your Lordship. Your Lordship, as Ankshita, the petitioner, is the resident of Uttar Coast. So if the law is violating her fundamental right, why should he leave her hometown and go to any other town to reside? And tomorrow future, if like Ankshita, 100 people comes and everyone will travel to any other state to get their marriage registered, then ultimately it's the problem of the law, Your Lordship. Why the law can be declared as void, Your Lordship? Under UCC, Your Lordship? Under UCC, it will not lead to null and void, Your Lordship. But because UCC is not allowing us to marriage, Your Lordship, because it says it's some conditions. Your Lordship, one section of UCC also states null and void. One section says non-registration is not dealt to be invalid. Simultaneously, section 23 of UCC, Your Lordship, may refer to 23, Your Lordship. Will not lead to invalidation. But 23 again says, if non-registration has been done, it will lead to void. So law is ambiguous, Your Lordship. One part, Your Lordship, I am just referring. Your Lordship, it clearly states non-registration heads to void marriage, Your Lordship. It does make registration of marriage compulsory. One part it is saying non-registration heads to void. Again part it is saying that if someone is not registering, that not leads to invalidation of marriage. So complete law is ambiguous, Your Lordship. So that was not a primary contention, Your Lordship, as Your Lordship wanted to know. Yes, section 4 gives the conditions for marriage, Your Lordship. So if the conditions are not fulfilled also, then we are denied registration. And one part it is saying if registration is denied, marriage is valid under 20. But again under 23 it is saying non-registration leads to void. So that is the ambiguous part we are challenging, Your Lordship. Your Lordship, 4-1, Your Lordship. 4-1, Your Lordship. Because according to UCC, polygamy is prohibited, Your Lordship. But under Muslim personal law, Zishan has the right to marry 4 wives. And so that is the part. If the UCC would not have been there, then Ankshita and the unborn child, if Zishan is willing, he could have married. But because of UCC, he has been prohibited. And for that, the unborn child's right and Ankshita's right are being violated, Your Lordship. Yes, Your Lordship. If UCC would not have been there, or if UCC would be declared unconstitutional, then personal law will prevail over Uttar Coast, and we can marry under our personal laws as per the Muslim personal law, Your Lordship. Your Lordship, it's not stopping us. Your Lordship is not stopping us to convert, but why we will go to another state for conversion? If we stay in Uttar Coast, it's mandating. If you are resident and you are living, you have to register. We can only convert if we go to another state. So why we will go to another state, Your Lordship? Your Lordship, again, section 6, Your Lordship. Section 6 of the UCC says, compulsory registration of marriage post enactment of UCC. And also the word shall in that section mandates that. So we are challenging that part, Your Lordship. Section 6, 20, 23, it all deals with ambiguous part, and for those ambiguity we are suffering, Your Lordship. If Your Lordship has no further questions, I'll move to the prayer. Your Lordship, I have completed argument 2 and 3. Yes, Your Lordship, I will move into the prayer, Your Lordship. In the lights of facts and submissions made hereinafter, the petitioner most respectfully pray before this honorable court that it may be pleased to hold, adjudge and declare that the present writ petition is maintainable under Article 32 of the Constitution, that the UCC of Uttar Coast is unconstitutional as its enactment and provisions violate the fundamental rights guaranteed under the Constitution and are inconsistent with the principles of secularism, federalism and participatory democracy, that the impending provisions mandating parental consent for individuals especially below 21 years of age for registration of live-in relationship is arbitrary, unreasonable and violative of Article 14 and 21 and must be struck down, and that the UCC of Uttar Coast failed to protect the right of paternity, legitimacy, welfare of the unborn child, violating the child's right to dignity and legal recognition, and the UCC unconstitutionally restricts the right to cohabitation and religious freedom practices, thereby infringing upon the freedoms guaranteed under Article 25 as well as under Article 21 of the Constitution, and Your Lordship may pass any such order relief of writ as the court deems fit. For this act of kindness, the petitioner shall ever remain duty bound and grateful, Your Lordship.
Greetings to the bench. For the clarity of the bench, the council would like to say that the memorial which is submitted, which has a red cover and a team code HR16 will be the memorandum which is referred by the council. And the council seeks permission to submit the compendium for the respondents. We have only one copy, Your Lordships. Apologies for the inconvenience. With the permission of the bench, the council seeks permission to begin. If it may please this honorable court, this is counsel appearing on behalf of the respondents in the case of Ankshita Reti versus State of Utkarsh and another. Your Lordship, to start off with my arguments, the council would like to reinstate on the facts of this case that this particular case surrounds around a pregnant woman right now who did not register a relationship, who wants to secure the paternity. The council would like to state that none of the submissions which were presented by the petitioners were in the line of the factual matrix itself. And Your Lordship, the council seeks permission to start with the challenging of the jurisdictions of why this petition was approached to this honorable court. Your Lordship, this present petition under Article 32 is not maintainable per se before this Honorable Supreme Court, Your Lordship, because there is no violation of fundamental rights as such as has happened in this particular case.
No, first you sought permission to mention the facts of the case, to which we said yes.
Oh.
So did you mention them?
Indeed, Your Lordship, the council just wanted to give a summary or a small glimpse of the case. If the council would be grateful to reiterate the entire facts as well. Indeed, Your Lordship. Your Lordship, this particular case is situated in the state of Uttar Kosh, a democratic state and it's known for its secularism. And Your Lordship, a uniform civil code has been passed in this. There were various objections which were dealt with, and this particular enactment was passed with the presidential assent. And at the same time, a woman called Ankshita Reti, who entered into a live-in relationship in Bumba, who is also a resident of state of Uttar Kosh, did not register her live-in relationship. And once the live-in relationship is terminated, and when she came back to Uttar Kosh, and when she finds out that she's pregnant, now she wants to come and register this live-in relationship to secure the paternity of the child. Your Lordship, to secure the paternity of the child, the government has already made enough measures, and concerning arguments will also be made by the councils here. Your Lordship, here, since the Registrar General denied registration based on the fact that she is currently not in a live-in relationship, and the man she wants to register with a live-in relationship is right now married. Thereby, if registration happens, it will equal to polygamy, which is not allowed in the UCC, Your Lordship. Thereby, Your Lordship, Ms. Ankshita Reti has approached this honorable forum. Your Lordship, in this particular case, as the council was reiterating, there is no violation of fundamental rights per se. It was the opposite councils have clearly tried to blind the facts that she is the one who did not register. The enactment is extremely clear on the fact of how they should register, and especially when a resident is outside the jurisdiction, outside Uttar Kosh, how they must register. They can register in Bumba itself in the nearest registrar office. But Your Lordship, Ms. Ankshita Reti has denied to follow the same. Thereby, Your Lordship, coming to this particular forum in contention of violation of fundamental rights, when there is no violation of fundamental rights per se, is unmaintainable, Your Lordship. Your Lordship, the council will be dealing with issues A and B, and as per the memorandum, it will be 1 and 2. Much obliged, Your Lordship. Your Lordship, thereby, the council would like to reinstate the case of Romesh Thapar versus State of Madras, that the case held that mere disagreements with legislative policy and administrative decision cannot. Your Lordship, this particular case is not in the compendium, but it is a landmark judgment, and the Honorable Supreme Court held the same, that disagreement with administrative decision cannot be a reason to approach this particular forum. And Your Lordship, this was also reiterated in the case of P.N. Kumar versus MCD, and the citations will be forwarded, Your Lordship. Indeed, Your Lordship. Your Lordship, the Council would like to would pass on the citations as early as possible. Much obliged, Your Lordship. Your Lordship, thereby there is no grave injury, there is no violation of fundamental rights, and they have also not exhausted the alternative remedy. Your Lordship, this was passed in state of Uttar Kosh. They could have very well approached this High Court of Uttar Kosh, and it was said in this particular case, Your Lordship, the Supreme Court discourages the petitioners approaching to the Supreme Court when the same can be settled in the High Court, Your Lordship. This is well itinerated by this honorable forum itself. And Your Lordship, the citations would be 4 SEC 609. PN Kumar versus MCD. Four SCC 609, Your Lordship. If I may proceed, Your Lordships. 1987. 87, Your Lordship. Much obliged, Your Lordship. Your Lordship, in that particular case, this case will have to be dismissed right away. But in the spirit of the competition, the Council would like to proceed with the argument issues in hand. Much obliged, Your Lordship. Your Lordship, and with regards to the maintainability, the Council would also like to contend on one thing. The Council had said that they had approached this honorable forum so that when the other states are implementing UCC, it won't be a difficulty. Your Lordship, this has already happened. When Goa enacted the UCC, in the case of Jose Paulo versus Maria Luisa, which is in the compendium, flag number 5, the Supreme Court had in fact praised the Goa's UCC, which is exactly what the state of Uttar Pradesh has also implemented. Your Lordship, thereby there is already a well-established precedent for the contentions of UCC in the Honorable Supreme Court itself. Thereby the answer that they had given for why they had approached this Honorable Court itself is invalid, Your Lordship. With that particular contention, Your Lordship, the Council would like to proceed. Your Lordship, in this, the Supreme Court had observed that there was a striking balance between the customary practices and the legislation, Your Lordship. It is well highlighted in the compendium submitted as well, Your Lordship. In flag number 5, Your Lordship. Your Lordship. It is highlighted in the judgment copy, Your Lordship. Flag number 5, Your Lordship. Your Lordship, apologies for that, Your Lordship, but this was the ratio which was given in this particular judgment, Your Lordship. Thereby, there has already been an established case which deals with the UCC in this honorable forum, Your Lordship. If your Lordships are satisfied, may I please proceed with the arguments, Your Lordship? Much obliged, Your Lordship. Your Lordship, the first issue in hand, which deals with whether the enactment and provisions of the UCC, particularly those prohibiting polygamy and the registration of live-in relationship with a married man, is violative of fundamental rights under Article 21 and is inconsistent with the constitutional principles such as secularism, federalism, and requirement of public consultation, Your Lordship. Your Lordship, the Council would like to humbly contend that it is not violative. Much obliged, Your Lordship. Much obliged, Your Lordship. Your Lordship, in this particular case, the enactment is not violative of Article 21, Your Lordship. Your Lordship, here, on the other hand, what is violative of the Constitution is the concept of polygamy, which is inconsistent with the constitutional principles, Your Lordship. Your Lordship, with this particular issue, the Council would like to submit the arguments in a threefold manner. The first sub-issue deals with whether the constitutional validity of UCC under Article 21, Your Lordship. Your Lordship, here, this UCC was enacted in the constitutional vision of the social reform and gender equality. Your Lordship, let's take the concept of polygamy as such, Your Lordship. A man is allowed to marry 4 women and have 4 wives, Your Lordship. Your Lordship, this concept, this customary concept is itself portrays inequality and gives against the Article 14, Your Lordship. Your Lordship, it is well understood that customary practices must be entertained in the legislations, Your Lordship, but only customary practices which are not violative of fundamental rights, Your Lordship. Your Lordship, when the customary practice itself gives gender inequality, why will the government enact more legislations to protect it, Your Lordship? And Your Lordship, apart from that, there are multiple multiple cases from this honorable court itself to quote Khurshid Ahmed Khan versus State of Uttar Pradesh, which is in the flag number 1, and along with Ram Prasad versus State of Uttar Pradesh, which intended that polygamy is not a very essential practice, Your Lordship, and only essential practices of a particular relationship must be entertained through enactments of the state, Your Lordship. And Your Lordship, with the argument that the opposite counsels pose that this practice has been essential for multiple decades, Your Lordship, in the Quran verses itself, verse number 4.3, Your Lordship. Your Lordship, this verse depicts that this is not an essential practice. It can be entertained if the individual wants it in his own, and if he is able to treat all the 4 wives equally, Your Lordship, but this is not an essential practice. And nowhere in any legislation it has held that the practice of polygamy in Islamic traditions is an essential practice, Your Lordship. And when we apply doctrine of essentiality, when the legislative is making laws, Your Lordship, only essential customary practices must be kept in favor, Your Lordship. And Your Lordship, with the argument presented by the petitioner, where they said there is an inconsistency with Section 4 and Section 7 of the UCC, Your Lordship, the council begs the opposite council to look into Section 7 surplus to clearly that particular part where they allow customary practices did not specify that they will be allowing polygamy in the first place, and in the second place it was allowed only for individuals who had married before 2010. And Your Lordship, why 2010? 2010, that is because that is when Compulsory Registration Act was passed in Uttarakhand, Your Lordship. The council would like to submit a copy of that as well. And Your Lordship, this particular enactment was passed to actually save women and actually have a regulation on who has entered into bigamy and polygamy, Your Lordship. And which is why any relationship or any marriage which has been entered before 2010 was allowed as per customary practices, Your Lordship. And again, as they had stated, polygamy was not mentioned in that customary practices, Your Lordship. Your Lordship, the entire submissions which was presented by my learned opposite counsel were just enactments which were wrongly interpreted. Your Lordship, there were no substantive case laws substantiating the same, and there were only wrongly interpreted case laws which were vaguely read, Your Lordship. This is a testament to the statement the council just made, Your Lordship. This is not a valid contradiction to actually go against the first issue in hand, Your Lordship. And Your Lordship, as submitted, polygamy in Islamic practices is not necessary, Your Lordship. To further substantiate on this, Your Lordship, the council would also like to say the harm principle which is recognized in Shreya Singhal case, where the court cannot infringe the rights upon others. Your Lordship, in this particular case, if we do allow registration of live-in relationship or marriage for Miss Ankshita, what will happen to the rights of Miss Nushrat, Your Lordship? That needs to be taken into consideration, Your Lordship. Your Lordship, right to when polygamy happens, there are multiple cases filed in this honorable court itself, Your Lordship, challenging the concept of polygamy in Islamic tradition, that it is against the right to dignity which is guaranteed under Article 21, Your Lordship. Your Lordship, the petitioners have come to this forum saying Ms. Ankshita's fundamental rights have been violated when it has firstly not been violated, and they're also trying to violate the rights of another individual who have rightly followed all the legislative policies, Your Lordship. Thereby, Your Lordship, here that also needs to be taken into consideration. And Your Lordship, this particular enactment also passes the threefold proportionality test, Your Lordship, which is legitimate aim, which is to have gender justice and monogamy and legal clarity when it comes to the concept of live-in relationship, Your Lordship. Part 3 of the UCC alone, and is one of the first legislation which gives legal clarity on live-in relationships, Your Lordship. That is the legitimate aim of this particular enactment. And we talk about rational nexus, Your Lordship. It achieves rational nexus by preventing relationships that are legally and functionally replicate polygamy, Your Lordship. It is preventing those relationships which are not constitutionally entertained, Your Lordship. And when we talk about proportionality, Your Lordship, the preventing polygamy in no way hinders the child's rights, Your Lordship, because there are multiple legislations formed which gives the child equal rights if it would have gotten even if it was a legitimate child, Your Lordship. Your Lordship, thereby this enactment achieves proportionality by also reducing polygamy and also securing the child's rights, Your Lordship. Thereby it passes the threefold test. And Your Lordship, when we talk about Article 21, the other limb of Article 21 is personal liberty, Your Lordship. Your Lordship, in this particular case, is legally, Ms. Zihan Khan is legally married to Ms. Nushrat. Your Lordship, the council is very well aware that this is a constitutional bench and it is more objective to argue on this on law, Your Lordship. But in this particular case here, Your Lordship, the conceived child will have rights irrespective of he is legitimate or illegitimate, and Your Lordship, and if it was registered according to section 379 of the UCC itself, any child born out of a live-in relationship is given legitimate status, Your Lordship. Thereby, Your Lordship, it is not violative of the child's personal liberty also, nor is it violative of the father or Ms. Anshita's personal liberty, Your Lordship. And even if there exists any violation, Your Lordship, just for argumentative purposes, the council contends that it does not violate, and only for argumentative purpose, Your Lordship, even if it does violate, it very well comes under the part of procedure established by law, which is well established in the case of Maneka Gandhi versus Union of India, which my opposite councils also had referred to, which talks about the restriction must be fair, just and non-arbitrary, Your Lordship. Your Lordship, in this particular case, the legislation has been more than fair, just and non-arbitrary, Your Lordship. Your Lordship, here the legislation has been formulated in a sense where there is no right snatched away from the child, and again, on the other hand, protecting all the individuals by preventing polygamy, Your Lordship. Your Lordship, again, registration of a live-in relationship cannot have retrospective applicability, Your Lordship. If the court entertains that, firstly, the law cannot apply retrospectively unless it is specified, Your Lordship. There itself, it gets clarified. And even if this honorable bench allows, then, Your Lordship, all the relationships, all the live-in relationships from the past 10 to 20 years, the clients, the people will be coming in forward to claim this, Your Lordship. That cannot be entertained, and it has also not been. Much obliged, Your Lordship. Your Lordship, they have not come to register a relationship that live-in relationship that is currently ongoing, Your Lordship. Your Lordship, there has been provisions in the UCC itself for two, Your Lordship. If you're going to start a live-in relationship, there is a particular procedure to register, and if you're already in a live-in relationship, again there is a particular procedure to register, Your Lordship. The petitioners in this particular case have not followed either of it, Your Lordship.
How do you practically say that when you start a living relationship, then you have to register? Because in a practical scenario, you cannot apprehend that you will be living. When you are in a relationship, it does not consummate a particular marriage or anything like that. So it might be for a week, for a day, for a month. So how do you expect a person to come and register as soon as they are starting a living relationship?
Your Lordship, when they're intending to have a live-in relationship, Your Lordship, this particular enactment is enacted only to regularize this concept of live-in relationship and to protect the women and the individuals who are in it, Your Lordship. Thereby, registration and regulating this particular institute is necessary, Your Lordship. And in that particular case, Your Lordship, it is understood and it is accepted that the live-in relationship might not have a definitive tenure of how much it is going to sustain, Your Lordship. But even in that hand, Your Lordship, registration is important, Your Lordship, because this entire enactment has been enacted for the regularization of this purpose, Your Lordship. And in this particular enactment itself, when one party deserts another party, maintenance is also allowed, Your Lordship. In that particular case, Your Lordship, registration is required to claim such rights, Your Lordship. And those rights were also given by this Honorable Supreme Court, and in the light of those judgments, this particular enactment has been enacted, Your Lordship. If Your Lordship is satisfied.
One more question. Your whole argument revolves around polygamy. Was it not allowed before UCC?
No, indeed not, Your Lordship. Your Lordship, in the legislation that we had submitted, the Compulsory Registration Act, even in that legislation was passed to protect women from polygamy and bigamy practices, but also to make sure that they get the proper rights, Your Lordship. Your Lordship, yes, Your Lordship, the customary practices such as polygamy has not been clearly stated, Your Lordship, and Your Lordship,
Specifically restricted for a guy following the Islamic community not to have more than one?
Your Lordship, the concept of polygamy is not only pertaining to the Islamic community, Your Lordship. The concept of polygamy can also be entertained, is also practiced in a lot of communities of Hinduism. Thereby, there is no need to inform that it is only polygamy is restricted only for Islamic communities, Your Lordship.
So, what you intend to say that by bringing this act, you have actually stopped polygamy?
We are,
Rather than you would have made some amendments in the
Personal.
Communities Act and stopped it rather than bringing a whole new act in.
Your Lordship, the intention to bring UCC was not only to stop polygamy, Your Lordship. There were multiple other things, and Your Lordship, the concept of UCC had evolved in when the Constitution had evolved itself, Your Lordship. The legislation has only waited until the particular community is ready to accept this, Your Lordship. And Your Lordship, this brings me to the next sublim, which talks about public consultation, Your Lordship. Your Lordship, if the Council also answered your question. Indeed, Your Lordship. Indeed, Your Lordship.
In that field, there already were multiple Hindu acts, such as the Special Marriage Act, which was enacted by the Parliament. Now, the state legislature has enacted this particular law. So, can you just highlight the fact that legislative competence of the state government to legislate on a field which is already being covered by a statute which has been enacted by the Parliament?
Your Lordship, personal laws come under the purview of the concurrent list, Your Lordship. And
It comes under the concurrent list. And in case if there are two antagonistic questions that on the same subject matter, one by the Parliament, one by the state legislature, which will prevail?
Your Lordship, in that particular case, it is well known that the state legislature will prevail, Your Lordship. The central legislature will prevail, Your Lordship, because the central law will overrule the state law. The council is aware of that, Your Lordship. But this particular... Indeed not, Your Lordship. Your Lordship, there has not been any substantial evidence that is violative of the Hindu Marriage Act or the Islam... Indeed, Your Lordship. Your Lordship, even in Special Marriage Act, polygamy practices are not allowed, Your Lordship. There is no particular violation of there is no contradictory between the already established laws and this UCC, Your Lordship. UCC is brought in forward because the state also has liberty to make laws and... Yes, Your Lordship. Indeed, Your Lordship. Your Lordship, for marriages, there is no sanctions, Your Lordship. The council would like to clarify.
And for the same subject matter, even in the Hindu marriage, there is an option of either we can register or we may not register. So legislating on the same matter which has already been covered by an act of Parliament, whether it is not a case of legislative overreach by the state government.
Your Lordship, to answer the question that Your Lordship just posed, Your Lordship, there is no clear violation between those two enactments, Your Lordship. And to be specific on what Your Lordship's asked, Your Lordship, the UCC does not hold the marriages which are not registered as void as contended by my co-counsel, opposite counsel, Your Lordship. It is also accepted, and legitimacy status for a child, Your Lordship, specifically is given even for a child who is in a live-in relationship, even for a void and voidable marriages. Your Lordship, that will be dealt by my co-counsel in the third issue, Your Lordship. If Your Lordship is satisfied, may I please move on to the... Yes, Your Lordship. Your Lordship, now the Council would like to submit my submissions on the public consultations, which is strongly opposed by my opposite counsels, Your Lordship. Your Lordship, the Council would like to contend that public consultation did happen, and the government had received more than 2 lakhs applications and public consultation, public opinions in that regard, Your Lordship. The evidence for the same has also been submitted to the court, Your Lordship. There was an online portal portal which entertained all the public opinions with regards to this particular issue, Your Lordship. I'm sorry, Your Lordship, pardon me. Your Lordship, this is for the reference of the judges, Your Lordship. Even if there is no, even if the submission is not made, it is very well established fact, and it is also in the memorandum footnote number 41, which has attached the website link itself, Your Lordship. Thereby, in that website, Your Lordship, it entertains all public opinion with regards to the same matter, and almost 2 lakh public opinions were consulted and then enacted, Your Lordship. It is a well established fact in the factual matrix that there were oppositions, Your Lordship, but then these public consultations were made and it had passed through a proper order, and presidential assent was also taken, Your Lordship. Thereby, Your Lordship, this particular enactment was constitutionally competent and is going towards federal harmony rather than what the petitioners are contending for, Your Lordship. Your Lordship, if your Lordships are satisfied with the first issue, may I please move on to the second? And the Council would be very much happy to answer any queries posted by the bench, Your Lordship, with regards to that. Indeed, Your Lordship, the Council the Council would like to apologize for the technical difficulty, Your Lordship. Indeed not, Your Lordship. Indeed not, Your Lordship. It was a technical issue that the Council faced. Much obliged, Your Lordship. Your Lordship, when we come to the second issue, as per the Moot proposition, issue B, Your Lordship, which deals with whether parental consent for the age group of 18 to 21 is required, and if it's valid under Article 14 and 21, Your Lordship. Your Lordship, the Council would like to seek the help of the petitioners to find the word consent in the UCC and parental consent in the UCC and the rules, Your Lordship. There has only been parent notice, parents information. Your Lordship, the UCC and the government have been more than fair and reasonable to give only notice, Your Lordship. And the contention that my opposite counsel had presented, that the response from them will, if they had denied it, we don't know if the registrar will deny the same, Your Lordship. Your Lordship, there is no talk about getting response from the parents, Your Lordship. When there is no provision which states that the parental opinion will be taken into consideration, there is no denying, Your Lordship. Much obliged. Indeed, Your Lordship. Indeed, Your Lordship. The Council would like to beg to differ in that opinion, Your Lordship. Your Lordship, the enactment has been very clear, Your Lordship. We are allowing them to have a legally recognized live-in relationship from the age of 18, Your Lordship. But to the age between 18 to 21, the reason why parental notice is required, the Council will be substantiating in her arguments, Your Lordship. And it is not violative of Article 14 in the first place, Your Lordship, because it very much follows and very much satisfies the principles of intelligible text, differentia and rational nexus, Your Lordship. Your Lordship, to substantiate on that, Your Lordship, there are multiple scientific studies which say that the prefrontal cortex of the brain only formulates after the age of during the age of 21. Your Lordship, the parental intimation comes under the registration process, Your Lordship. So thereby, if that is not done, the registration process will be hindered, Your Lordship. That the Council is very well known of, Your Lordship. Thereby, Your Lordship, there is no parental consent violating, Your Lordship. There is there is no parental concern that restricts the registration, Your Lordship, but parental notice definitely, Your Lordship. And the reason why for this particular age group the parental notice is required is because they do not have, in that particular age group, they don't have something called as economical independence, Your Lordship. Your Lordship, in this particular enactment itself, Your Lordship, if there is desertion, even in a live-in relationship, he or she must give maintenance, Your Lordship. Your Lordship, in the age group of 18 to 21, where most of the adults are studying, Your Lordship, will the students have enough financial capabilities? Apologies, sir. Yes, sir. 18, Your Lordship. Indeed, Your Lordship. Indeed, Your Lordship. It is also established in the Indian Majorities Act. 18, Your Lordship. Indeed, Your Lordship. Indeed, Your Lordship. Much obliged, Your Lordship. Your Lordship, there is no receiving from the parents, Your Lordship, but if the parental notice is not done, it does restrict the registration process, Your Lordship. We don't give it, Your Lordship. We don't give it, Your Lordship. Your Lordship, because this is a small restriction placed, Your Lordship, and from section 18 itself, registration is allowed, Your Lordship, if the small restriction is also complied with, Your Lordship. Your Lordship, if parental notice is followed, live-in relationship for age group of 18 is also allowed, Your Lordship, which is why the enactment states that live-in relationships are allowed from the age group of 18, Your Lordship. Your Lordship, if the information for the parents is not given from the petitioners or from the individual, then we do not give the registration, Your Lordship. We do not look forward for any response or any opinions from the parent side, Your Lordship. Indeed, Your Lordship. Your Lordship, the Moot proposition has used the word consent, Your Lordship, but then that does not go align with the enactments of the UCC, Your Lordship. Your Lordship, thereby, to the interpretation of the council here, the concern is the notice which must be provided by the petitioner to the parents, Your Lordship. I believe since it's a competition, the council would like to take the spirit of the competition and interpret according to the stance, Your Lordship.
So you accept that part that the consent of the parents was not present when you rejected the registrar rejected?
Indeed, Your Lordship. Your Lordship, parental consent is a requirement which is legally valid, Your Lordship. That is what the council would like to submit, Your Lordship. Your Lordship, if the Lordships want to proceed with the concept which is present in the factual matrix, which talks about consent, Your Lordship, the council would like to present arguments even for the consent and even for the notice, Your Lordship. Your Lordship, with respect to the parental concern, as interpreted with the provisions of the UCC, Your Lordship, the UCC does not have any provisions which talks about the consent, Your Lordship. No provision in the UCC. Indeed not, Your Lordship. Your Lordship, the Moot proposition, when it refers to parental consent, indeed, Your Lordship. Indeed, Your Lordship. Your Lordship, in that particular case, Your Lordship, the UCC does not have any per se, any regulations with the idea of consent, Your Lordship. It only talks about the notice. And Your Lordship, the Moot proposition is also silent, or the case is also silent on the fact if notice was sent, Your Lordship. The case is also silent on that fact. So, Your Lordship, it is fair to assume that the notice and the consent is used alternatively, Your Lordship. Your Lordship, since the facts are silent on the part of notice, the council would like to interpret it in that regard, Your Lordship. If Your Lordship is satisfied, may I please move on? Much obliged, Your Lordship. Your Lordship, thereby young adults who, to answer the previous question which my Lord posted on that age of 18 is taken into consideration for voting and for having a PAN card, but why not for live-in relationship? Your Lordship, when it comes to having voting rights, and it is also well established that in the Indian Majority Act, it says 18 only, Your Lordship. But then, Your Lordship, in personal laws, and when it comes to a right which also involves into another individual, and they will have to, they will also be responsible for another individual, parental consent or parental notice is required, Your Lordship. And Your Lordship, voting is not going to violate anyone else's rights, Your Lordship. It is not going to violate anyone else's decisions, Your Lordship. It is an independent decision which is posted. Whereas, Your Lordship, getting into a live-in relationship is going to affect another individual's lives. Thereby, Your Lordship, that is the entire reason why we have put a bar from 18 to 21. We're not restricting, Your Lordship. We have gone for a very least restrictive and a very reasonable way where only parental notice or consent is required. Indeed, Your Lordship. Your Lordship, again, marriage for 18 is only allowed for women, Your Lordship. It's 21, Your Lordship, the council. Indeed, Your Lordship. Your Lordship, to answer that particular question, Your Lordship, the concept and the institute of marriage has been well established in this country, Your Lordship. It has been a well-known practice and it has been well established through decades, Your Lordship. Whereas live-in relationship is a new concept and it has still not been accepted throughout, Your Lordship. We are only trying to regularize and try to make it more amicable for everyone and trying to protect everyone's rights here, Your Lordship.
So when the state now marriage has to be registered and parents' inclination are necessary, would it also come under the live-in relationship if they have to register their live-in relationship as soon as they come to marriage? Would the parents' permission still be required?
Your Lordship, there is no permission from parents that is required, Your Lordship. It is only intimidation. Yeah, indeed, Your Lordship.
So in any part of the scenario, in any factual scenario, when you are entering into a living relationship, giving a consent to the parent or taking the consent from the parents, would it not further the whole idea of getting into a living relationship? Is it not violating the fundamental right of the basic, those two individuals who wants to get into the living relationship?
Your Lordship, in that particular stance, Your Lordship, the Council has explained why it is necessary, Your Lordship, and this is not completely restrictive, Your Lordship. The individuals are well within their rights to get into a relationship without their parental consent after the age of 21. There is no bar in that regard. Only since the people of 18 to 21 fall under a vulnerable category, the state have posed this measure, Your Lordship. And Your Lordship, it also in the case of Navdeep Singh Johar versus Union of India, though it is well as, and Supriya Chakrabarti, it is well emphasized that marriage rights are not given for the LGBTQ community, but then live-in rights are established, Your Lordship. Your Lordship, in that particular stance, the court also did mention that it is well within the state's rights to take the welfare of the individuals and to make sure that they are not getting into any relationship that is manipulative or that does more harm to themselves, Your Lordship. And in that regard, Your Lordship, this particular restriction is only done to protect the welfare of individuals in the vulnerable group, Your Lordship. Your Lordship, as substantiated by the Council previously, marriage and the life which falls upon that, Your Lordship, it has been very well established and it has been followed for multiple years. It is not a new concept or it is not upon the state to actually look into it as deeply as the concept of live-in relationship, since it's an evolving and it is a very vulnerable status, Your Lordship. It is an evolving concept that needs more protection for individuals who are fall under the vulnerable category, Your Lordship. Thereby is why we have posed this particular restriction, irrespective of it's a girl or boy, Your Lordship. All individuals are treated equally, and this particular restriction is put for them for a period of 3 years only to protect them and in the concern of their welfare, Your Lordships. If Your Lordships are satisfied. Much obliged, Your Lordship. Your Lordship, thereby it is established that parental consent is not violative of Article 21, Your Lordship. And Your Lordship, again, it is also, the Council would also like to substantiate that it also passed the test, which is a proportionality test, which is laid down in the modern dental college test, Your Lordship, which is it must have rational connection, scientific data, least restrictive means, and must strike a balance between rights of individuals and the interest of the society, Your Lordship, which is exactly what the state has done in this particular case, Your Lordship. And Your Lordship, again, the council, opposite council had put up an argument saying that it would be violative of privacy, and they put Puttaswamy case, Your Lordship. Your Lordship, it is a very well known fact that Justice Puttaswamy versus Union of India dealt with Aadhaar card and the personal information with regards to that. Personal decisions were not dealt in that particular case. So the council is a little confused of why privacy and why the concept of why the case law of Justice Puttaswamy was brought here. It became like a category where if you say privacy, it becomes Justice Puttaswamy's case, Your Lordship, when that particular case and this particular case have no relevance at all. And this talks about personal decision and that talks about personal information, Your Lordship. The council would like to reiterate on that as well. And Your Lordship, pardon me, Your Lordship. Your Lordship, the council is contending to the statement which was made by my opposite council that said Puttaswamy case can be referred for this particular case in hand, Your Lordship. The council is, the entire judgment talks about the personal information and the Aadhaar card act was enacted, Your Lordship. Indeed, Your Lordship, it is to regularize it, Your Lordship. But then, Your Lordship, that is not violative of anyone's privacy here, Your Lordship. And it is definitely not violative in this particular case, Your Lordship, because here registration itself has not been allowed. And Your Lordship, it is also in the case of J.K. Tirupati versus State of Jharkhand, the High Court dismissed the right to privacy in live-in relationships, Your Lordship. Your Lordship, the concept of live-in relationship is currently evolving, and a little bit of state's intrusion. Your Lordship, this is High Court judgment for the perusal of the court, Your Lordship. It does not have any binding value, Your Lordship. Only for the perusal, the council is contending this, Your Lordship. Your Lordship, in the same case, to refer to what the council was saying, Your Lordship, the concept of live-in relationship is currently evolving, Your Lordship, and a little bit of state intrusion for the own well-being of the public is allowed and is well within the rights and is not violative of Article 21 or 14 here, Your Lordship. And Your Lordship, the council would also like to state the case of Charan Lal Sahu, which is in the compendium flag number 7, where the Supreme Court upheld the state's authority to intervene in the individual's welfare when it is contended necessary, Your Lordship. The same judgment has been involved in the compendium and has been highlighted, Your Lordship. Thereby, Your Lordship, it is very well established that it is not violative the restriction, which is very least restrictive in manner, is not violative of Article 14 or Article 20 and 21, and it is well within the state's rights to post a small restriction in order to protect the welfare of the individuals, Your Lordship. The council would like to answer any questions posed by the bench, Your Lordship. And Your Lordship, the council would also like to contend on the fact that they had made their entire arguments on the fact that live-in relationship is not mandatory, Your Lordship. When the first section of Part 3 of the UCC, which deals with live-in relationship, and the very first section says that it is a compulsory and it is obligatory for every individual who gets into a live-in relation to register, Your Lordship. The entire argument which was presented saying that it was not mandatory, the council is really confused of where such interpretation and from which barrack they had made such interpretation and posted their arguments with respect to issues 1 and 2, Your Lordship. With that, if I may be of no assistance to this honorable bench, the council would like to pass the podium to them. Indeed, Your Lordship.
It's a private decision between two major individuals to get into a living relationship.
Indeed, Your Lordship.
It is not coming from the part that you asking me to register to get into a living relationship. It may be a temporary process for both the individuals, both the major individuals. Why would you ask me to register
Indeed not, Your Lordship. Your Lordship, here the need for regularizing of live-in relationship has been substantiated in multiple law commission reports, Your Lordship. In fact, before the enactment of UCC, it was formulated and the origin comes from a law commission report, Your Lordship. And that particular law commission had encouraged, and the legislative and the judiciary through various pronouncements had encouraged the legislative to make and regularize and to recognize the concept of live-in relationship, Your Lordship. Thereby, Your Lordship, and which is also in the memorandum footnote number 44, Your Lordship, the law commission report. Your Lordship, in that particular case, the UCC is only giving legal recognition and is establishing that live-in relationship are legally recognized relationship. And as for the part of giving consent, or like why do I have to register to be in a live-in relationship, Your Lordship, it is to give proper legal recognition and to make sure other rights which are entitled if you are in a live-in relationship has been given to you properly, Your Lordship. For example, Your Lordship, the domestic violence. Your Lordship, even if they are in a live-in relationship, if they are subjected to domestic violence, they have to get the relief, Your Lordship. In that stands, Your Lordship, only to have a recognition and only to have a record of which the registration has been implemented, Your Lordship. That is why registration is required at this particular juncture of time, Your Lordship. Is Your Lordship satisfied, or may I proceed, Your Lordship? Much obliged, Your Lordship. Your Lordship, the Council would like to pass the podium to my co-counsel if Your Lordships do not have any further questions. Much obliged. It was honor pleading before this bench.
Greetings to the Honorable Bench. So the Council will be dealing with issue C and D of the Moot proposition and issue 3 and 4 of the Moot memorial, Your Lordship. So issue 3 deals with, does the denial of registration of the marriage or the live-in relationship of Ankita and Mr. Khan impact the right to paternity, legitimacy and welfare of the unborn child, and can such rights be read along with Article 21, Your Lordship. This issue explicitly talks about the rights of the unborn child and rights of the mother, Your Lordship. I was very surprised that why my learned counsel did not talk about the rights of unborn child and were just stressing on the arbitrary nature of the action of Registrar, Your Lordship. So this case, so the action of Registrar General was made in strict compliance with the Uniform Civil Code that was enacted in Uttar Pradesh, Your Lordship. This is a validly enacted law which got the presidential consent and which did follow the procedure of public consultation and came into force. The petitioner argued that the unborn child's right, and legitimacy. While we emphasize that these concerns, is important to know that the child's right and the registration is independent in nature, Your Lordship. The rights of the unborn child is already protected under various family law and guardianship laws. Denial of the registration of the parents does not equitate with the denial of inheritance or maintenance or any other rights that has to be upheld to the unborn child, Your Lordship. There are several laws that protect the rights of an unborn child itself. The state's refusal to register the relationship between the parents does not violate any constitutional or statutory rights of the unborn child, Your Lordship. The process of the status of legitimacy comes from a valid registration or valid relationship between the parents. In the present case, there is no valid relationship between the parents itself, as the live-in relationship is not registered, and it lasted only for a period of 6 months. That too, it ended due to allegations of abuse. The 6 months period is not considered to be a long-term long-term period to cohabit and does not fall under the presumption of marriage, Your Lordship. In the landmark case of Tulsa versus Durgatya, it was held that a minimum period of 6 months and a long-term period of 2 years has to be mandated for a live-in relationship to fall under the presumption of marriage. In the present matter, the relationship between Ankita and Mr. Khan did not fall under this category, as it was a walk-in and walk-out relationship. As
But your act doesn't talk about any minimum requirement for months or years to register a live-in relationship, right? Does it?
Indeed, yes, Your Lordship.
Then why have you not put it in your act?
About the minimum period of for
What are you saying that it was less than 6 months, there was abuse. Those have not been the reasons for denial. The reason for denial has been that
Yes, Your Lordship.
Consent was missing.
Yes, Your Lordship. Indeed, yes,
And
Your Lordship.
polygamy.
Yes, Your Lordship. So, the main denial of registration of the relevant relationship is 2 reasons, Your Lordship. First one is about the age, Your Lordship. And the second one is the person who's going to get the Jason Khan, who's already having a wife, a validly recognized marriage, is attempting to register a live-in relationship, Your Lordship. Here, the rights of the woman who he already married, that is Miss Nusrat, is also affected, Your Lordship. Not only the petitioners are stressing only about the rights of Miss Ankita and Jason, and they are completely avoiding the rights of Miss Nusrat. Nusrat, who is a woman who got validly married to a Muslim man, is not subject to such restriction as polygamy, as allowing the registration between Ankita and Jason affects the rights of Muslim women, that is Ankita, Your Lordship. There are various cases where Muslim women have come up challenging the polygamy, Your Lordship. In the present, in the case of Samiha Begum versus Union of India and Nafisha Khan versus Union of India, there were several Muslim women who came up to the Honorable Court and challenged the validity of polygamy. This itself shows the dissatisfaction of polygamy in the Muslim law itself, Your Lordship. So, registering the live-in relationship not only affects it mainly affects the rights of Miss Nusrat, and as the contention by the petitioner, it does not affect the rights of an unborn child, as giving the legitimate status alone does not go hand in hand with the constitutional principle and morality, Your Lordship. The child born out of an unregistered relationship does not mean a child is not given any rights, Your Lordship. There are a lot of rights in the Indian legislation itself that protects the rights of an illegitimate child. As already mentioned by my co-counsel, in the section 379 of the UCC Act that was passed by Uttar Kosh, it says that children born out of a validly registered live-in relationship is legitimate. In this case, the child is not legitimate because the registration is not done. And I also accept that the welfare of the child is the paramount consideration, Your Lordship. The state is not refusing the welfare of the child. We are upholding the welfare of the child, and the parents have come to the Honorable Court just seeking for the paternity of the child, and they want to register the live-in relationship to secure the paternity of the child. Here, the requirement to register the live-in relationship itself is not required, as the paternity is already given, Your Lordship. I would like to state that there are 2 types of illegitimate children, Your Lordship. When it comes to right to identity, there are 2 types of illegitimate child. One, the child who's an unrecognized illegitimate child and a recognized illegitimate child. An unrecognized illegitimate child is one who is not acknowledged by its own biological father. In that case, the surname of the father will not be given, Your Lordship. And in the contrary, in the second case, recognized illegitimate children are children who are recognized by the biological father, and in that condition, they are allowed to use the surname of the father. So, the right to identity is still upholding. Even if the child is illegitimate, the welfare is still being the paramount consideration, and the right to identity is upheld, Your Lordship. And then when it comes to right to maintenance, section 125 of the CRPC, currently 144 of the BNSS, it states that right to maintenance is given to children below the age of 18, and maintenance should be given irrespective of the birth status, Your Lordship. So the right to maintenance is also upheld in the present case. And then when it comes to guardianship, there are several cases where guardianship is still protected under section 6 of 1.
Tell me one thing, what would be more welfare thing for first thing, calling him illegitimate and not by not registering marriage would be more well. Other, you can have the marriage registered and child. Won't that be more meaningful to call it a welfare for the child? Rather, you can get the marriage registered, because in the factual scenario, it has not been specifically stated that the Nusrat has objected to that marriage. So now you can have that marriage registered and then call this child a legitimate child, rather than differentiating. How would you differentiate two types of
Yes, Your Lordship, but the concept of legitimacy follows from a legally registered or legally recognized relationship, Your Lordship. A child will be called as legitimate child if it is born out of a valid marriage or a validly registered. The UCC also recognizes that a child born out of a valid live-in relationship is also legitimate. But in the present case, there is no legality at all, Your Lordship. So just putting the blanket ban and putting forward the contention of child welfare to register the relationship, a legal relationship between the parents, is not justified, Your Lordship. And in the eyes of law, right to family are given for illegitimate child also, Your Lordship. And illegality does not follow legitimacy, Your Lordship. There are, Your Lordship, there are cases where although the rights of the second marriage is not upheld, but the right of children was upheld, Your Lordship. In the landmark case of Revana Sittappa versus Mallikarjun, flagged in number 9, it was held that children born out of a relationship outside valid marriages are innocent and must be entitled to same rights as other children, including maintenance and property, Your Lordship. But in that case, it was held that the right to maintenance, inheritance, and it was emphasized that the right to maintenance, inheritance, or everything was given because the child was innocent, and the court wanted to protect the best interest of the child, Your Lordship. But it still denied the right of the woman, that is mother, to get registered under. Denied the recognition of second wife to that mother, Your Lordship. In the same case of Kala Devi versus Nihar Singh, the court held that while a woman who entered into a relationship during subsistence of a prior marriage could not claim to be legal wife, her child was still entitled to maintenance, Your Lordship.
We all accept that the child has all the right, even if he is illegitimate. So we do not question, even the petitioners do not question. Get all the benefits even if it is called illegitimate.
Yes, Your Lordship.
Even they did not point out so. But what would be more meaningful for the child to be? For a child who would be born with a father's name and a mother's name, apart from Nusrat. If it is not objected by Nusrat, why can't it be registered?
Yes, indeed, yes, Your Lordship. But the contention of the petitioners is they in the first place they wanted to register their relationship for the sake of upholding the rights of the children. They wanted to secure the paternity and the rights of the unborn children. Only for that they came to register the live-in relationship. When the register refused to register the live-in relationship, they wanted to register the marriage. Their primary contention is to protect the rights of the unborn child. But in the present matter, the rights of the child is already upheld. The rights of the child is already protected. Then why do they want to register their live-in relationship is the contention, Your Lordship. And then we accept that it is the state's duty to protect the rights of the vulnerable group, that is unborn child. But this protection the protection to uphold the rights of unborn child and register the live-in relationship does not go hand in hand, Your Lordship, because there exists a conflict between the constitutional principle itself, Your Lordship. If we register the live-in relationship between Ankita and Jason, there will be a lot of people coming saying that to protect the rights of the children, they want to procure the relationship between the parents. But it is absolutely not necessary, as the rights is already upheld. When there is no need for it, when there is no need for a when there is no need for a protection of the child rights, just keeping it as a blanket ban and coming in forward to register the marriage is not valid, your lordship. And then giving a legal status to their relationship of Ankita and Jason is not valid, as it was not merely a proper relationship. It was a walk-in and walk-out relationship that ended in 6 months, and that too it ended due to allegations of abuse, your lordship. So we believe that this is not a right relationship that has to be secured. And in the second place, the relationship itself, registering this relationship violates the principle of bigamy, your lordship. The procedural requirement that was the procedural requirement to register the relationship does not align in the present matter, your lordship. Your lordship, so the state is not bound to register a relationship and which is not legal, your lordship. So in the present case, first of all, there is no age consent, your lordship, and then it is challenged by bigamy, your lordship. So in that case, registering the ribbon relationship, because, as it was discussed by my co-counsel in the previous issue, till the Ankita attains the age of 21, the notice of the parents is required, your lordship. So in the present case, your lordship, as the facts is silent about the same, yes, your lordship, the law is clear that notice has to be passed to the parents, your lordship. In the present case, Ankita is refusing even for giving notice to the parents, your lordship. Your lordship, what we are referring to, pardon, your lordship. It does not mention as she refused, your lordship, but the acknowledgement from the parents is required, your lordship, to register the live-in relationship between the couple. In the present matter, there is no acknowledgement. Yes, your lordship, as the facts is silent about this matter, it's subject to be interpreted by the... Your lordship, but okay, indeed, yes, your lordship.
And we are still not satisfied that why we need a consent of them between 18 to 21. When those can get married at 18 without any consent. Why she needs a consent for registering, not consent, but even a notice for registering a legal relationship.
Your lordship, the purpose of putting this restrictive clause is to differentiate, is to draw a slight differentiation between marriage and live-in relationship, your lordship. So live-in relationship does not procure any of the legal. So the acquiring such a. So much, pardon, your lordship. The live-in relationship, there is a distinction between live-in relationship and marriage, your lordship. Yes, your lordship. Yes, your lordship.
There is a child who is coming out of not even a registered marriage, not even a registered marriage. Then isn't the child's rights are getting affected just because a registrar somewhere decided to deny the registration just because he is taking his consent?
But your lordship, the purpose of having this consent is that the people falling under the group of 18. So, lordship, the acknowledgement is required for getting the live-in relationship registered, your lordship.
You have the copy of the UCC?
Your lordship, only the relevant provisions has been attached in there.
Which you are presenting, sir is asking which particular portion says that the consent is accepted.
Yes, Your Lordship, but we just added the relevant provisions of the compendium in the UCC, Your Lordship. So to move on to the next part of my argument, Your Lordship. Lordship. So the presumption of marriage and legitimacy through long-term cohabitation, as already discussed in the Tulsa versus Durgatia case, is not upheld, Your Lordship. The concept does not apply here, as living together for a substantial period of time is not upheld, Your Lordship. And then the case that, and then which was discussed by the best interest of the doctrine of best interest of child, which was discussed and which is emphasized more in this issue, tells that any judgment or anything, any order that has to be passed should be in the best interest of the child, Your Lordship. In the present matter, we are not denying the best interest of the child, Your Lordship. We are giving all the rights to the child, unborn child, and not pushing it to a vulnerable position, Lordship. Thus, we are still upholding the best interest of the child, and it does go hand in hand with the constitutional principles as well, Your Lordship. And to answer the question that was raised regarding the social stigma, Your Lordship, in the eyes of law, practicality is important, Your Lordship. But giving a child legitimate status and giving so much rights to a child is upheld by the legislation in the so many years, Your Lordship. The question of social stigma is based on the societal reforms, and it should be emphasis on education and reforms of the society, Your Lordship. In the present matter, the practicality and social stigma is considered, Your Lordship, but they do not have a contention that the registration, it can be upheld only when the registration is upheld, Your Lordship. And there are several other rights that is still given to the child, such as the Juvenile Justice Act, which protects the right of the unborn child, and the right to children to free and compulsory education Act 2009, the maintenance rights, the inheritance rights. All the rights are still given to the unborn child, irrespective of the registration of marriage or live-in relationship, Your Lordship.
Child later on, and the wife will fight for her maintenance because they lived in a relationship because they cannot register.
Yes, Your Lordship.
Later, for the paramount welfare of the child, both the parents would try to have the best welfare, they would try to give the best for the child.
Yes, Your Lordship.
They would also try to have the possession of the child, mother and father both. This will lead to multiple litigation between both the parents. So is this provision not leading to multiple concoctions between the societal, if you are not recognizing the marriage at this position, which is there in the factual position right now, would it not lead to later multiple litigations, and is it not overall against the welfare of the child? The child will sit and cry as to where would he would go under the Guardians and Warrants Act, the matter will go on for years. So if you are not recognizing the marriage, you are actually leading it to multiple litigations later.
Yes, Your Lordship, but the primary custody and the primary guardian of the illegitimate child will be with the mother, according to... Yes, Your Lordship.
Leading to multiple litigations, would this question not be given to a court and will decide the matter? So is it the welfare of a child when you are not recognizing the marriage?
But Your Lordship, registering this kind of relationship also attracts a pile of litigation, a pile of cases from other people who have cohabited together, and they would want to claim the status of live-in relationship, and they will want to use the rights protected under live-in relationship, Your Lordship. Giving registration for this kind of relationship will also attract other cases and other vulnerable groups, which cannot be justified, Your Lordship. As in the present case, the welfare of the child, as you said, it is the paramount consideration, Your Lordship. But the primary custody is given to the mother, and primary guardian will be mother. When the custody of the child will be in the in the control of the mother, and if there is any changes, or if there is anything to be changed, that has to be passed through the family law procedures established. Pardon, Your Lordship.
If If there is any dispute, then it has to be decided by the court of law. However, the petitioner side asked one more, they pointed out one more provision which is related to each other, which you have not satisfied us to the part. Section 6, which is in contradiction to section 20, I believe. Yes. What did you say on that part? Section 6 and section 20 are contradictory to each other, where section 6 says compulsory registration of marriage is required, and section 20 says non-registration not to invalidate the marriage.
Your Lordship, there is a clause which says that registration of the live-in relationship is obligatory, Your Lordship. So I believe that obligatory means it is a compulsion, Your Lordship. So there is no option that is available to the couple, Your Lordship. It says that people who are if either of the parties is resident of Uttar Kosh, it is mandatory for them to register their relationship. I do not know where the position of option is given to the couple to register their marriage or not, your relationship or not, Your Lordship.
Section 20. You have copy of this?
No, Your Lordship.
You are arguing on this?
Yes, Your Lordship, but we did not refer to that provision as there was no contradiction, as it was already mentioned that it was obligatory for the couple to register, Your Lordship. The law is very clear that when it is obligatory, it is mandatory for the couple to register. Much obliged, Your Lordship. So if the Lordship is satisfied with the third issue, may I please move on to the next issue in hand. So the next issue is that whether the UCC as applied in this case unconstitutionally interferes with personal laws and religious freedom guaranteed under Article 25 and the right to cohabit under personal choice, Your Lordship. So I would like to put forth my argument in a threefold perspective, Your Lordship. The UCC of Uttar Kosh was enacted to fulfill the constitutional vision of uniform civil laws as mandated under Article 44 of the Constitution, the principles of state policy, Your Lordship. It applies uniformly to all citizens regardless of religion or community. This legislation prohibits polygamy and bans the registration of marriage or live-in relationship involving either of the parties who is already married. Thus, this is a secular framework that governs civil relationship based on the equity and non-discrimination, Your Lordship. This is a neutral and application which is inconsistent with the secular ethics of the Constitution, Your Lordship. And moving on to the first of my argument, which talks about the doctrine of essential religious practices, Your Lordship. As upheld in Moot case, the Supreme Court held that only those practices that are fundamental and integral to the religion are reflected under Article 25, Your Lordship. Again, it was reiterated in Mohammed Hanaf Qureshi and Ismail case, which are both landmark cases, where it was reinforced that mere permissibility under personal law does not equate to constitutional protection. Here, in the present case, Jesus' action is neither mandated by nor it is essential to the Islamic religion, Your Lordship. And his attempt to bypass this monogamy laws under the pretext of religious liberty does not fall under the ambit of Article 25, Your Lordship. And then moving on, the petitioners argue that ban on polygamy violates Article 25, Your Lordship. But Article 25, Clause 2, Clause B says that the Constitution of RN expressly permits the state to enact laws for social welfare and reform. Even if such reforms override with religious practices, if it is for the sake of welfare and reform, it can be passed, Your Lordship. The court, again in the case of Khurshid Ahmed Khan versus State of UP, upheld that service rules that penalize polygamous Muslim employees, reiterating that polygamy is not an essential religious practice under Islam and can be validly restricted. In the present case, Mr. Jason's desire to enter into a second relationship while already being thus is not protected under the religious faith or between the interfaith relationship, your lordship. This is not a right, your lordship, but this is just a personal preference which is available to Mr. Khan, which must not yield the shelter of secularism and constitutional norms, your lordship. And then, as argued by my co-counsel, this is not a case of arbitrary or selective denial, your lordship. The registrar was merely enforcing his right, enforcing his duty, and as enacted by the clear provisions of the secular law. The UCC does not single out or disappropriately affect any religious group, your lordship. It simply bars on all citizens, regardless of the community, caste, or any other discrimination that it was facing, your lordship. Thus, Article 14 cannot be invoked here, saying that rational nexus or rational axis or twin test should be followed, your lordship. Again, in the landmark case of David versus State of Haryana, the Honorable Court held that polygamy, even if it is permitted by the religion, it is not protected as a fund and can be regulated or prohibited by law. The UCC does exactly the same, your lordship. The concept of polygamy is not an essential practice and it cannot be upheld. And it is for the social reform and welfare community. It can be it is subject to reforms, your lordship. It does not have just enacting UCC does not have to do anything with Article 25, as Article 25 Clause 2 Clause B already says that if it is for reform and welfare, it can be very much amended and a new enactment can be formed, your lordship. This brings me to Article 21 as well, your lordship. We acknowledge that right to privacy, dignity, and right to choose partners protected under Article 21. But however, this right is not absolute, your lordship. In the landmark case versus Union of India, the Honorable Court held that privacy is subject to reasonable restriction. And again, in the case of Supriya Chakravarti versus Union of India, it was said that no unqualified procedures be established to protect the right, fundamental right enshrined in Article 21, your lordship. Thus, it was also held that public interest and public welfare must be the paramount consideration, and it has to go in hand with the public welfare. So, in the present case, much obliged, your lordship. So, in the present case, the Registrar General's refusal does not interfere with the with the petitioner's personal rights or liberty. It's just enforcing the lawful limits of UCC, lordship. So, it does not have anything to do with Article 21, as Article 21's right to privacy and personal choice as invoked by the petitioner is not absolute, your lordship. So, if the lordship is satisfied with issue 4, the council seeks permission to move on to the prayer of the case. So, wherein, in the lights of the facts stated, issues raised, arguments advanced, and authorities cited, the counsel for the respondents most humbly pray before this Honorable Supreme Court of IN to gracefully grant the following reliefs. Number 1, to dismiss this current petition with cause. And number 2, to uphold the validity of UCC provisions, especially provisions governing live-in relationship, and affirm that the registrar's action is go hand in hand with the constitutional provision, your lordship, and pass any order or orders as this court deems fit and proper in the circumstance of the case and in the interest of equity, justice, and good conscience. For all of this act, the counsel for the respondents would be duty bound and forever pray. All of which is most respectfully affirmed and submitted before this honorable court. This, the counsel would like to rest the case. It was honor pleading before this honorable court, your lordship. Thank you.
Thank you, counsel. If it pleases the honorable bench, we are now moving for the rebuttal and surrebuttal rounds. A few important instructions before we proceed. The rebuttal must strictly respond to the arguments raised by the opposing side during the oral rounds and shall not raise new arguments. The same rules of decorum and structure apply as during the main pleadings. A time reminder will be given at the 2-minute mark. If a speaker exceeds the time limit, the bench may allow or deny any extension at their discretion. Honorable bench, with your permission, we may now proceed with the rebuttals. Counsel for Petitioner, you may now begin your rebuttals.
Your Lordship, I begin with the rebuttal. Much obliged, Your Lordship. First of all, Your Lordship, the Defense Counsel didn't answer properly the reason behind the parental consent part or the classification on the basis of age. Further, we also want to make clear that about the orphans, Your Lordship. If the parental consent is there, there are also orphans who may register themselves, they may be in relationship. What about them? The Act is also silent about the orphans. If parental consent is so mandatory, then the orphans will not be able to register, Your Lordship. That depends on the question, Your Lordship. Also, Your Lordship, the Holy Quran part that the opposite counsel stated, in the verse of Surah and Nisa, it clearly states that a man, a Muslim man, if he wants to take care of an woman and he can marry up to 4, the only requirement, primary requirement is he should be able to treat all women equally. And if he is capable to do that, Islamic law allows that. So in our case, that satisfies, Your Lordship. And also, the opposite counsel stated about the live-in relationship part, the time limit, long-term relationship, short-term relationship. But the definitional framework of the same act under section 3(4)(b) of UCC doesn't specify any time period of the live-in. It only defines what is live-in relationship, not 1 year, not 1 month or 6 months, Your Lordship. And rather the defense counsel focusing on our contention and tried to prove it beyond reasonable doubt, they focused on the third party, Nusrat, who is not even a party to the case, Your Lordship. If someone is not at a party to the case and Ankshita being the party, her right has to be given primary importance, Your Lordship. Your Lordship, also the section 6 and 20 of marriage registration remains unanswered by the opposite counsel, and they focused on the obligation that is the live-in relationship. But we were asking about the marriage registration part, which is ambiguous, Your Lordship. Your Lordship, also, if there is no need to registration, if live-in registration is optional, then what is the need to make a law? Everything was well and fair. If registration is all main thing and that is optional, then what is the need of a law to enact, Your Lordship? Your Lordship, also further, the age limit, above 21 years of age. They stated that the economic condition on the girl 18 to 21 years of age. So above 21, the job guarantee is also in question. It is not sure that above 21 she will get a job in future. That is also remains a question. That doesn't remain a reasonable reason behind that, Your Lordship. And Your Lordship, 379 clause 1 and clause 2 part, they raised that 379 clause 1 makes it mandatory for the live-in relationship, whereas 379 clause 1 is not applicable on us, Your Lordship. 379 clause 2 is applicable on us, because here one of the citizen is a resident, that is Ankshita, but Jishan is a Bomba, and we were in relationship outside. So 379 clause 1 doesn't comes into picture. 379 clause 2 comes into picture, and it is very cleverly hidden by the Defense Counsel, Lordship. That much, Your Lordship. Oblige, Your Lordship.
With the permission of the bench, may I please begin? Your Lordship, to start my rebuttal from the last contention that my opposite co-counsel made, that we did not refer to the section of 379 subclause 2. Your Lordship, that is the exact section that we had referred, and that is the only section which talks about if residents are outside the territory of Uttar Kosh, how they are supposed to register. They are supposed to register in their nearest register office, which was not done by Ankshita. I don't think the counsels have hidden it, Your Lordship. That is our first argument presented, that Ms. Ankshita did not register, and there have been certain provisions for her to do it. And Your Lordship, again, when my opposite counsel presented the argument of above 21, the age between 18 to 21, why we have placed the restriction, and Your Lordships also said that we are not satisfied with the explanation. Your Lordship, the counsel like to reinstate that the state have gone through the most least restrictive measure, Your Lordship. And in this least restrictive measure, we are only trying to block the most vulnerable group that we can focus on. Your Lordship, or there is a lot of talk of even after 21 there is no employment, but Your Lordship, in that case, then even we should not allow in 18 itself, Your Lordship. We are going for a most least restrictive way while protecting the individuals as well as giving them the rights that they deserve, Your Lordship. And Your Lordship, as per registration of marriage, Your Lordship, with the factual matrix, what we are aware is they first wanted to register the live-in relationship to secure the paternity of the child. Your Lordship, it has clearly stated in the paragraph 8 and 9, this entire case has been filed only to secure the paternity of the child, where my opposite counsels presented no arguments on the securing the paternity of the child, and only concentrated that they wanted to register the marriage. Your Lordship, first they approached the Registrar General to register a live-in relationship. Once that was denied, they wanted to register a live-in marriage, Your Lordship. Again, we believe that they had done it only for the interest of the child, Your Lordship. Thereby, we are clarifying. Much obliged, Your Lordship. Thereby, Your Lordship, marriage is a secondary option to them. And again, Your Lordship, we are restricting marriage on valid grounds, Your Lordship. And to move on to the next contention, Your Lordship, the term on live-in relationship. Your Lordship, the term which my co-counsel referred for live-in relationship was emphasized in a landmark judgment, and which was put in forward for the bench's reference, Your Lordship. But in this particular issue in hand, and for the enactment of UCC, though there is no tenure mentioned, Your Lordship, but there is a compulsion of registering a live-in relationship, Your Lordship. Even if it was a tenure less than 6 months or less than 2 years, at least there must be registration, Your Lordship. In the failure of both, we are unable to have legal recognition for the relationship, Your Lordship. And also it must be kept in mind, Your Lordship, they are not asking for a live-in relationship registration which is in current terms. The relationship was already terminated. They are asking for a registration which was post the current status, Your Lordship. And Your Lordship, again to reply to the rebuttal, the verses of Quran, Your Lordship. Your Lordship, we can submit the verse of the Quran. Much obliged, Your Lordship. Your Lordship, in that particular Quran itself, even when they did translate, nowhere did it say that it was an essential practice and it must be followed, Your Lordship. And the state is only bound to protect essential practices and not obligatory not practices which are just took into considerations, Your Lordship. Thereby, it is also re-emphasized in the Javed case, Your Lordship, which the councils had also previously submitted, Your Lordship. And Your Lordship, with respect to parental consent, to again clarify, Your Lordship, parental consent is only taken for that particular age group to have more to save the vulnerable group. And if Your Lordships are satisfied with that argument, the council would like to rest, Your Lordship. And Your Lordship, to sum up the rebuttals, the council would also like to mention that their prayer and the arguments which was presented was completely irrational, and the sections which much obliged, Your Lordship. It was honor pleading before this court, Your Lordship. Much.
Thank you, Counsel. That concludes the rebuttal and sur-rebuttal rounds. With that, all oral submissions for this session have concluded. The courtroom proceedings shall conclude.
एक सेकेंड So, on behalf of the entire Faculty of Law, Kalinga University, I, Harleen Kaur, gives you a heartfelt gratitude by accepting our invitation for judging the final rounds for the same and sparing your valuable time to come here all the way from different cities and all to judge the final round. And moving forward, I would just like to request Mrs. Darshi Sharma Gohe, Assistant Professor, Faculty of Law, Kalinga University, to kindly felicitate Advocate Vinay Jain sir, founder at VKG Law Offices, Raipur, with a certificate and a memento. Ma'am, please. Thank you, sir. I'll again request ma'am to kindly felicitate Advocate Palash Tiwari, sir, founder and managing partner, Lexloft LLP. I'd like to request ma'am to kindly felicitate Advocate Animesh Tiwari, sir, AT Law Chamber, Bilaspur. Thank you so much. I'll just request the judges to kindly share the feedback with the teams, if possible.
Both the teams did very well, but some fine tuning was required. Challenging a vires of a statute. That is what I was hinting at. For the petitioner to make out a case, you want such and such provision to be struck down. Right? Then you base your entire premise on the basis of that. If this is violative of Article 14, Article 20 or any provision or any repugnancy is there. Argued everything. You've argued everything from top to bottom. But it was not properly compartmentalized. That is an advice which I can give it to you. It has to be compartmentalized. If challenges to the vires challenge करने के लिए ये 5 provision है, 6 provision है, और these are the judgments of Supreme Court, whereby you challenge the vires of the statute, and then that is how you articulate. This side did very well in defending it out, especially you. You did very well, the first speaker. But then again, defending the vires again would be you were able to make out the intelligible differentia, but not connected to the object. That part was missing on your part. That is my 2 cents on this topic.
So I appreciate your efforts and what you have put in. You guys would have already learned that if there are 3 judges, then you should always keep an extra copy. That's it. So, and the most important part is your presentation was very wasn't highlighting part. You guys can use it on the proper cues. This is what we learned because sir also pointed it out earlier that you can not on a rush manner because the time, if it is required, if you are presenting it well, the judges can give you an extra time. And that was very well presented on your part. You can put your arguments on step by step, and one more important thing to both the teams, that whenever you're giving the citations, the title, the citation would also come in place, or at least the year, so that we can get the reference which specific judgment have we referred to the judgment earlier, or do we know that judgment or not. Just yelling out the judgments won't help us at the present juncture, especially when you're growing up with that speed. But overall, it was a great presentation for both of you.
So I think both the teams, you guys have done amazingly fantastic job. Kudos to you. And my brothers have covered it all, so I don't have anything extra to say, because it will be unfair for me to judge you, I think personally, from where we stand, but where you guys stand, you are far better than probably I was personally, I can say. And it's a everyday learning, so we are also learning. So you guys have done, your hard work is evident, there's no doubt about it. Your presentation, you have tried to do to the best of your capacity. Yes, there are few things, there are always shortcomings, perfection is never there, you learn every day, so keep learning. And the best way is probably read as many judgments as, and this to all, everybody who's pursuing law, read as many judgments as you can in your area of interest, and watch as many court proceedings as you can, and that is the only way to learn. And be fearless. Be fearless and be very truthful before you are submitting anything to the court. That these two, I think, will play a lot important role in taking you ahead. So thank you so much. It's been a pleasure watching you all, and thank you so much, Kalinga University, for inviting us in and for giving us this opportunity. And kudos to the whole team. Fantastic management. Thank you, everyone.
In any case, please be back by 2:15 in auditorium, that's in ground floor. You can contact